All rise. The Criminal Court for Jeanes County, Tennessee is now in session. The Honorable Justice Dwight Tarwater presiding.
Thank you, ladies and gentlemen. Please be seated. Welcome. This is the Criminal Court for Jeanes County, Tennessee. This case is State versus Capps. Is the prosecution ready?
Yes, Your Honor. First, may we introduce ourselves?
Please do. Please do.
I am Ophelia Cherry-Poulet, and I, along with my co-counsel Xavier Warren.
Good evening, Your Honor.
And Margot Ross.
Good evening, Your Honor.
Represent the state in this case. Additionally, we will be calling 3 witnesses. First, played by Aaron Joyce, Ronnie Montgomery.
Good evening, Your Honor.
Next, played by Bronson Schmidt, Brady Stoker.
Good evening, Your Honor.
And finally, played by Henry Gatto, Andy Wilkes.
Pleased to meet you.
Additionally, the
Thank
state
you,
has...
Mr. Wilkes. Pleased to meet you. And counsel, I got everybody, I got your sidekicks' names, Mr. Warren and Ms. Ross, but I did not catch your last name.
Cherry-Poulet, Ophelia Cherry-Poulet.
Cherry-Poulet?
Yes,
Okay.
Your Honor, thank you. Additionally, the state has a few pretrial motions. First, pursuant to Rule 13, we asked to have our own timekeeper in the jury box.
Your own timekeeper in the jury box.
Pursuant to Rule 16, we asked that witnesses be present for this trial and not sequestered.
Okay, well, wait a minute. Let me take the first one first.
Oh,
and
sorry, Your Honor.
before we take up your pretrial motions, let me get acquainted with the defense side here,
Of
and
course.
then I'll give both sides a chance to make their motions.
Of course, Your Honor, thank you.
Thank you, thank you. And, all right, so who represents Mr. Capps?
Your Honor, good evening. My name is Cy Turner. Today I'm joined by my co-counsel, Mr. Kenny Royer. Good evening, Your Honor.
Mr. Royer, Mr. Turner.
And Mr. Vishy Parikh. Good evening, Your Honor.
Vishy Parikh.
Parikh, yes, Your Honor.
Did I get that right?
Yes, Your Honor.
Okay.
And together we represent Mr. Jules Capps.
Okay.
Would Your Honor like for our witnesses to introduce themselves? Or?
Sure, since I heard from the state's witnesses.
Yes, Your Honor. First we'll be calling Mr. Jamie Lett. Good evening, Your Honor.
Good evening, Mr. Lett.
Lay, Your Honor.
Lay, L-E-I-G-H.
Yes, Your Honor.
Okay.
Now, Mr. Lay is played by Mr. Charlie McIntyre. Mr. Alex Giles.
Good evening, Your Honor.
Good evening, Mr. Giles.
Played by Frank Pierce. And Mr. Jules Capps. Good evening, Your Honor.
Mr. Capps.
Played by Alexander Ritter. And that's it for our roster.
All right, so let me take up the state's preliminary matters first. All right, so what, you don't like our timekeeper? Is that, you brought your own? Is that what we're doing here?
No, Your Honor. We would just ask to have our own timekeeper in the jury box.
Oh, in the jury box.
Yes.
Is there an objection?
There's no objection, Your Honor. In fact, we'd also like to have our own timekeeper.
Well, I will apply a well-accepted legal principle called the goose and gander rule, and I will allow you both to have your timekeepers in the jury box.
Thank
So
you,
both
Your Honor.
motions are granted.
Thank you, Your Honor.
Thank you, Your Honor.
And did you have a second motion?
Yes. Pursuant to Rule 16, we ask that witnesses be present at the time of this trial and not sequestered.
Is there an objection?
No objection, Your Honor.
Additionally, pursuant to Rule 33, Sorry? May I continue?
I was just going to grant your motion before you.
Thank you, sorry.
Your motion's granted.
Thank
Okay.
you.
And And you've got another motion?
Yes, I have several others, just to preface.
Okay.
Yes, pursuant to Rule 33, we ask that the pre-agreed upon stipulations be entered into evidence.
And how do you propose to do that? Will you read those to the jury, or will you introduce written stipulations?
May my co-counsel publish a copy of those written stipulations?
Is there an objection to that?
No objections, Your Honor.
Granted.
May I approach the jury box with copies of the stipulations, Your Honor?
Yes. How are you going to put the stipulations in? Or do you propose just to hand them to the jury? Will you be reading the stipulations? Or how are those going to, how do you propose
Your
getting
Honor,
those
we
in the
have
record?
printed out copies of the stipulations.
Okay.
Yes,
Turn them over.
thank you.
You can pass those along.
A couple more things. Pursuant to Rule 36, we ask that lawyers be allowed to move within reason around the well.
You know something, I'm going to let you roam around all you want, okay? Just do not get too close to the witnesses,
Yes, of course, Your Honor.
okay? And don't go to the back of the courtroom.
Yes.
But as a person who'd like to roam around the courtroom, I want you all to be free to move and try your case.
Thank you, Your Honor. As a housekeeping matter, may we set up demonstratives and easels before any witness testifies and then flip them over once those exhibits are entered into evidence?
Yes, you may do that. Now, when you use a demonstrative exhibit, you should lay the appropriate foundation to do that.
Yes, of course, Your honor. And finally, I'd like to draw the court's attention to stipulation 28, which says that Jules Capps' phone number is 698-321-7774.
Say that one again.
Stipulation 28, and it says that Jules Capps' phone number is 698-321-7774.
Oh, that's the phone number?
Yes, it's the phone number, sorry.
All right.
Okay.
You don't object to that, do you, counsel?
No, Your Honor.
And with that, the
Grant.
state is ready for trial. Thank you.
State's ready?
Yes,
I
Your
think
honor.
that's what I heard you
Yes,
say.
Your honor, the
State's
state is ready for trial.
Defense, you ready?
Your Honor, a brief point of clarification. When Your Honor said we're allowed to roam around the courtroom, does that mean we don't have to ask permission before approaching the bench, opposing counsel, and the witness stand?
You should ask permission to approach the bench or to approach the witness. Otherwise, if you're not confined to the podium.
Yes, Your Honor. And one more slightly unusual housekeeping matter. My co-counsel, Mr. Royer, has been feeling a little bit ill all day. If Mr. Royer, for some unexpected reason, needs to get up and go to the bathroom, we ask for this court's leniency without having asked for a full recess.
We will accommodate Mr. Royer however he needs to be accommodated. And you just do what you need to do, and we'll take a brief recess until he can come and go, or however you want to proceed with him or without him.
Thank you.
Okay? And don't worry about that, all right?
Yes, Your Honor. Thank you. With that, the defense is ready for trial.
All right, so, all right, you all are doing a great job so far.
Thank you.
This is a criminal case.
Yes, Your honor.
Okay, and I'm going to give a few preliminary instructions, not only for the witnesses and counsel and parties, but also for the jury. If you will look in the jury box, you will see your jury. And I would ask the members of the jury first, well, let me do this. You've introduced your witnesses, and Ronnie Montgomery, will you be calling the officer, Officer Pennywise?
No, Your honor.
Dr. Stoker
Yes, Your honor.
and Andy Wilkes.
Yes, Your honor.
Is that correct?
Yes.
Okay. And the defendant, the witnesses on the defendant's list are Jules Capps.
Yes, Your Honor.
You can put your client on.
Yes, Your Honor.
Jamie Lee,
Yes, Your Honor.
Dr. Queen.
No, Your Honor.
Dr. Queen will not be called, and Alex Giles.
Yes. Yes, Your Honor.
All right, did any of the members of the jury know any of the counsel or any of the witnesses in this case? Okay, this is a criminal case. Mr. Capps, the defendant in this case, has been charged with a violation of 3 criminal statutes. The first is vandalism. Vandalism is the destruction of or damage to property, and you will be instructed on the elements of the crime of vandalism. One important thing about vandalism is that it can be a felony if the damage is over $1,000, or it might be a misdemeanor if the damage is under $1,000. And so if you find, in this case, that the state has proven every element of the crime of vandalism, then you must make a further finding as to the amount of the damage. If you find that the defendant has not committed the crime of vandalism, then that you may stop there and not answer the next question. The second criminal violation is aggravated burglary. Aggravated burglary is entrance into the property of another without their consent, with the intent to commit a felony. And the third and most serious charge is first-degree murder. In this case, this is a felony murder case. Felony murder is the killing of another human being during the perpetration of a felony or an attempt to commit a felony. So that's what this case is about. Is there anyone on the jury that can't judge this case fairly and hear the evidence fairly and give the defendant and the state a fair trial and follow the instructions of the court as I will give them to you? All right, is the jury acceptable to the state and to the defense? A good answer to that question is yes.
Yes, sir.
Yes, Your Honor.
Very good. In this case, because this is a criminal case and not a civil case, then the state is required to carry its burden of proof. This is a heightened burden of proof. In a civil case, the burden of proof would be more likely than not. So you might weigh the evidence like like Lady Justice would and see which way the scales tip. On the other hand, in a criminal case, the standard is heightened, and the state must prove every element of these charges beyond a reasonable doubt. And beyond a reasonable doubt means this: that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty is not demanded, but moral certainty is required. And this requirement is required as to every element of the case. With that, I think we're ready to hear opening statements. Counsel for the state, Attorney General.
Yes, Your Honor. May I proceed?
Yes, ma'am.
Your Honor, members of this jury, this is a case about promises made and promises kept. On July 5th, Jules Capps promised that Ronnie Montgomery would pay. And on July 8th, he kept his promise. And because of that, he is being charged with felony vandalism, aggravated burglary, and first-degree murder. Now, Mr. Capps and Miss Montgomery are next-door neighbors who rarely talk. But that changed the evening of July 5th. Miss Montgomery set off fireworks, and those fireworks scared Mr. Capps' dog, who ran away and got sprayed by a skunk. When the dog returned, Mr. Capps was furious about the smell. And he made a promise to Miss Montgomery. You will pay. You will suffer as I have to suffer, and that's a promise. Now, the next morning over the phone, Miss Montgomery received an anonymous phone call with that exact same promise. You will pay. She kept getting those same anonymous phone calls over the next 3 days, terrified of what they might mean. So she didn't answer. But she didn't have to answer. On July 8th, Jules Capps kept his promise. He made Miss Montgomery pay. He recruited his former employee, Jay Voorhees, to break into Miss Montgomery's house after she had left. Wearing clown masks from Mr. Capps' own store, they wreaked havoc on the place. And when they were done, Mr. Capps wrote, for one final time on Miss Montgomery's hallway mirror, his promise, "You will pay." But Miss Montgomery returned before Mr. Capps had left, and Miss Montgomery was armed. Terrified, she shot Mr. Voorhees in self-defense, and Mr. Capps fled the scene. Jules Capps left Ronnie Montgomery with a trashed, vandalized house and a dead body. Now, we are here today to prove to you beyond a reasonable doubt that Jules Capps is guilty of first-degree murder. He vandalized Miss Montgomery's house, he committed aggravated burglary, and his conduct resulted in the death of Jay Voorhees. Now, we'll prove this to you beyond a reasonable doubt, which means that at the end of today's trial, you should be willing to accept that Mr. Capps committed these offenses as a fact. Now, in order to prove that to you, we will establish 3 key facts. First, that the damage caused that night exceeded $1,000. Miss Montgomery herself will list just a few of the many items damaged or destroyed that night. And she will tell you that even if you consider a small sample of the total damage, it exceeded $1,000. She will also tell you that the burglars were not done with their damage when she arrived home, meaning that they intended to commit over $1,000 worth of vandalism, which is still aggravated burglary. Now, Miss Montgomery will also help establish our second key fact, that Mr. Capps' promise, his "you will pay," was repeated over and over again. He said it when he first threatened Miss Montgomery the night of July 5th. He said it again the next morning over the phone. And finally, he wrote it right on Miss Montgomery's hallway mirror. Now, this repetition isn't just a coincidence. Dr. Brady Stoker, a veteran handwriting expert, will tell you that in his expert opinion, the handwriting on the mirror is an exact match to a letter signed Jules Capps. And now finally, our third key fact, that the second intruder and Mr. Capps share connecting physical characteristics. Now, the second intruder wore a clown mask to cover his face. Andy Wilkes, a Salem local and former employee of Mr. Capps, will tell you that that clown mask matched exactly a clown mask sold at Mr. Capps' Halloween store. The second intruder also smelled like a skunk. Miss Montgomery will tell you that herself. And Andy Wilkes will take it a step further. He'll tell you about seeing and about smelling Mr. Capps while on his nightly walk. Just moments before the break-in, Mr. Capps smelled just like a skunk. Now, members of the jury, on July 5th, Jules Capps promised that Ronnie Montgomery would pay. And on July 8th, he kept that promise when he ransacked Miss Montgomery's house and forced her to take another person's life in self-defense. And now, the state makes a promise to you that Jules Capps will pay for his actions. When at the end of today's trial, we have proven each of these charges beyond a reasonable doubt, you must find Mr. Capps guilty. Thank you.
Thank you, General Cherry Poulet. Who would make the opening statement for the defense?
Cy Turner for the defense, Your Honor.
The floor is yours.
Yes, Your Honor. They under-investigated, but they overcharged. Now, Miss Cherry Poulet just tried to paint a picture of revenge, of a neighbor's violent payback for his dog getting sprayed by a skunk. She's asked you to believe that 2 armed intruders broke into a home, pointed a gun at the homeowner, supposedly over a smelly dog? When you heard that, if you thought, I don't know, that doesn't really make sense, that's because it doesn't. So how did we get here? in a capital murder trial with a smelly dog as the supposed explanation? Well, as you'll learn, the answer is twofold. First, you'll learn that the police uncovered evidence of a much more plausible explanation. You see, both the homeowner, Miss Ronnie Montgomery, and the deceased intruder had ties to an illegal gambling operation. And this whole break-in had all the earmarks of an effort to collect gambling debt. But you'll learn that the police failed to investigate that connection and ultimately arrested the wrong person. And second, the state, it wanted a murder charge. But you see, everyone in this courtroom agrees that the second intruder, whoever that was, never shot the first intruder. So the state's only option for a murder charge against the second intruder was through something called felony murder. But as the judge explained and will explain, the state can only pursue felony murder if the second intruder committed a felony. So the state found a couple felonies, namely aggravated burglary and vandalism, over $1,000. The problem is that there is zero evidence that the second intruder, whoever it was the one responsible for those crimes. We're here because they under-investigated, but they overcharged. Members of the jury, I'm proud to represent Mr. Jules Capps. Jules was born and raised right here in Jenks County. He walked into this courtroom presumed innocent, and even though he has the constitutional right not to, he's going to take that stand today and look each of you in the eye and tell you that he did not invade his neighbor's home. When the state charged Mr. Capps, it took on a burden to prove not only that Mr. Capps was the second intruder that night, but that the second intruder, rather than the first intruder, was responsible for $1,000 of damage. Mr. Capps, on the other hand, need not prove a thing for you to find him not guilty. However, over the course of trial, we will highlight 3 facts fatal to the state's case. First, both the homeowner and the deceased intruder had ties to an illegal gambling operation. You'll learn that the homeowner was seen frequently visiting that operation in the back office of a local pool hall. And 2 separate witnesses will tell you that the deceased intruder was an enforcer for that exact same illegal gambling operation. Fact number 2, the police failed to investigate this connection. Despite being provided with evidence that the homeowner was a gambler and that this break-in was actually related to gambling debts, you'll learn that the police simply overlooked this more plausible explanation. They never investigated the homeowner, her finances, her phone records, to uncover the truth. And finally, the third fact, the second intruder did not commit $1,000 of damage. The state will not call a single witness or present a single piece of physical evidence that the second intruder, rather than the first intruder, was the one responsible for that much damage. Members of the jury, this is extremely important because without that proof, the state's entire case fails. Members of the jury, all of this is why at the end of this trial, my co-counsel, Mr. Kenny Royer, will ask you to find my client not guilty. Because they under-investigated and they overcharged. Thank you.
Thank you, Mr. Turner. The state may call its first witness.
Yes, Your Honor, at this time, the state calls Ms. Ronnie Montgomery to the stand. And before I begin your direct examination, Your Honor, may I set up an enlargement of an exhibit we intend to enter into evidence? It will be
Is there an objection?
I have no objection, Your Honor. However, I ask that I may be able to reposition myself when the demonstrative is set up to be able to see the demonstrative.
You may do that. You may set your demonstrative up. and make sure the jury can see it and counsel can see it.
Thank you.
And you, I believe you are Ms. Ross, is that right?
Yes, Your Honor.
Okay, Ms. Ross. And Ms. Montgomery, you've taken the stand. Thank you.
Thank you.
Please stand, and I'm going to swear you in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Ross, you may proceed.
Thank you, Your Honor. One moment. My apologies, Your Honor. Please state your name for the court.
Ronnie Montgomery, ma'am.
What do you do for work, Ms. Montgomery?
I'm the proud vice president of Pointy Marker Company, based right here in Salem. Our markers have the ideal curvature of a Gothic arch, producing perfectly sharp, thin strokes every time.
How's your life down here in Salem?
Well, it's pretty nice and quiet. I live on Sanderson Street next to Jules Capps.
How would you describe your relationship with Mr. Capps?
Well, our relationship was friendly, if never the ideal Kramer-Seinfeld dynamic, at least until this past July.
Well, what happened this past July to change that dynamic?
Well, we started having some disagreements over celebrating the 4th. I like to extend my 4th of July celebrations a day or two, but this time around on the 5th, when I set off my fireworks, they scared his dog. Kruger ran straight off into the woods somewhere.
Were you able to find the dog?
Yes, but when the dog came back, poor Kruger had been sprayed by a skunk.
How did Mr. Capps react to finding out that his dog had been sprayed by a skunk?
Jules started raving, blaming me for the incident, saying, "You did this." But then they escalated, started yelling at me.
Was there anything Mr. Capps said during that altercation that stood out to you?
Yes. Jules yelled, "You will pay! And until the smell is gone, you will suffer as long as I have to suffer, and that's a promise." Things went from bad to worse the next day.
How do you believe things got worse the next day, July 6th?
Well, I woke up to my front lawn covered in toilet paper, and later I received a weird phone call.
Could you describe that phone call?
Yes, it was an anonymous call. When I picked it up, the first thing I heard on the other line was, "You will pay."
Was there anything else unusual about that phone call you received?
Yes, as I said, there was no caller ID, and the voice was so scary. I hung up immediately. I got several. I kept getting anonymous calls, but I didn't answer any more. I was spooked.
Let the record reflect that I'm showing what's been previously marked as Exhibit H to opposing counsel.
Exhibit H?
Yes, Your Honor. May I approach the bench to give you a copy?
Yes.
And may I approach the witness?
Yes.
Ms. Montgomery, could you please provide the jury with your phone number?
Of course. My phone number is 235-444-0564.
And is your phone number present on this document?
Yes, it's on this document.
Your Honor, at this time, the state offers Exhibit H into evidence. Its authenticity has been stipulated.
Any objections?
No objections, Your Honor.
It will be admitted. And is this the exhibit that you have the demonstrative of?
Yes, Your Honor. May I flip that over now?
Yes, you may.
Thank you.
Horizon Wireless, I see.
Yes, Your Honor. Ms. Montgomery, what's the first instance of your phone number appearing on this document?
It's here at 8:01 a.m. on July 6th.
Do you remember getting those anonymous phone calls on the morning of July 6th?
Yes, I got them all day on the 6th.
And what's the last instance in which your phone number appears under this document?
I see it here at 7:21 on the 8th.
And do you remember getting calls on the evening of July 8th?
Yes, like I said, I got calls all day on the 8th.
Ms. Montgomery, could you please note each instance in which your phone number appears under this dialed number column and the number 698-321-7774 appears under this originating number column?
Yes. As I said, it's first here at 8:01 on the 6th. Then again an hour later at 9:01. Then at 2:28 p.m. that same day. Then on the 7th, 7:59 a.m. Then 9:24, 3:25, and then the 8th. I see it here at 8:05. Then 2:45 p.m. Then 5:05 p.m. And finally, it's 7:21.
Thank you, Ms. Montgomery. Can you please tell this jury how many times in total between the morning of the 6th and the evening of the 8th you received a phone call from that 698 cell phone number I just mentioned?
Yes, I received 10 calls.
How did the afternoon of July 8th begin for you?
Well, I had been getting anonymous phone calls all day. But by the evening, I was so aggravated and scared that I just threw my phone across the room and went for my regular evening jog to clear my head.
Could you describe that jog?
Yes, well, it was pleasant, at least until I came home. When I got to my door, it was unlocked. When I stepped inside, my house had been ransacked. My first thought was to call the police, but I couldn't.
Why could you not call the police?
I didn't have time. I heard shuffling noises coming from my bedroom.
How did you react to hearing those noises inside your own home?
I keep a pistol near my front door for self-defense. I got it out, loaded it. My hands were shaking so much I could barely hold the gun steady.
What happened after you loaded the gun?
Well, I looked up to see 2 intruders walking out of my bedroom. They were wearing these big, bulky jumpsuits, and they had on these horrendous clown masks. They had these bright red lips and matching red hair, too.
Let the record reflect that I'm showing what's been previously marked as Exhibit C to opposing counsel. May I approach the bench, Your Honor?
Yes. Yes, you may.
And may I approach the witness?
Yes, you may.
Thank you. Ms. Montgomery, I understand that this is difficult for you, but can you please identify this picture?
Yes, this is the clown mask that the intruders were wearing on the night of the 8th.
Would you say this is a fair and accurate picture of those masks?
Yes.
Your Honor, the state offers Exhibit C into evidence. Its authenticity has been stipulated.
Object.
No objections.
It will be admitted.
Were the intruders wearing anything else of note?
Yes, the intruders were wearing gloves.
Ms. Montgomery, how did you react to coming face to face with these 2 intruders inside your home?
Well, one of them had a gun. He pointed it right at me. I did the only thing I could to save my life. I shot him before he could shoot me.
Was that intruder dead from the shot?
Yes. who I now know to be Jay Voorhees, was dead.
How did the second intruder react to you firing that shot?
He ran out the door. There was this awful stench, like a skunk. I remember scrambling for my phone to call for help. I called 911. Officer Pennywise came, secured the scene, secured my house. It was a wreck.
Could you describe the extent of the damage to your home for the jury?
Yes. The clowns had poured dish soap on and in everything. They poured it in my fish tank. It killed my betta fish, Reggie. Officer Pennywise asked me to give him a dollar amount of the damage. I could give you that now if you'd like.
Yes, can you please provide the jury with that estimate?
Yes. My TV was $500. My mattress was $400. My great-grandpappy's cologne, that beautiful floral sandalwood, the bottle was smashed. It was worth $300. And my hallway mirror, that was $75. In total, that's about $1,275, I think.
Objection, Your Honor, to both a lack of foundation and to Rule 403. May I be heard?
Did you say may I be heard? Is that what you
Yes,
said?
Your Honor.
Yes, you may be heard. Okay, so you're objecting based on lack of foundation.
And to Rule 403, Your Honor, 2 objections.
Okay, let me hear from you.
Count 2 of this indictment makes very clear that it's the state's burden to prove the amount of damage caused by the second intruder only, and not the collective damage of both intruders. And the state has not pursued accomplice liability, nor have they pursued criminal responsibility of another person. So the damage caused by both intruders cannot be attributed to one intruder or the other. Now, no foundation has been laid that all the damage that Ms. Montgomery just testified to was caused by the second intruder specifically. And the risk of that testimony misleading the jury substantially outweighs its probative value, which makes it inadmissible under Rule 403.
Okay, so the 403 objection is overruled, but let me ask you to respond to the foundation, the objection based on foundation.
Your Honor, pursuant to Rule 701, subsection B, witnesses are allowed to provide testimony about the values of the items that they own. Ms. Montgomery owns all of the items that she is testifying about, and therefore she is perfectly permitted to testify about their value to total up that estimate that she just provided.
I agree with you on that, counsel, but what about the argument that that the damage is attributed to one of the intruders as opposed to the other intruder?
Your Honor, any questions? Well, first of all, I'd like to add that no witness to be called in this trial could testify as to which intruder did or did not commit that vandalism. Any question as to which intruder may or may not have committed the vandalism should go to weight and not admissibility. The $1,000 in damage is highly probative to this case, and there's no reason why the jury shouldn't at least be able to hear testimony about the estimate. But any questions about the weight of the estimate with respect to who committed each act of vandalism could certainly be asked about by Mr. Parikh on cross-examination. I would have no objections to that.
So do you have, can you link the defendant, Mr. Capps, to the value that she just testified about? How would you do that, counsel?
We know that the second intruders were both in the home, both burglarized the home, and both committed the damage. No witness called can say which burglar did or did not commit each act of vandalism. But both of them were responsible for committing it, and therefore it's tied to Mr. Capps.
Okay, Mr. Parikh, I'll give you the last word.
Your Honor, I agree that both intruders were responsible for damaging Mrs. Montgomery's property. However, like I stated before, the indictment is very clear. It explicitly states that if Jules Capps was the second intruder, first of all, and if the intruder was Jules Capps, that Jules Capps vandalized over $1,000 property. Now, Like Ms. Ross just said, there's no witness that can testify to which intruder damaged what property, which is exactly what the point I'm making.
All right, your objection's overruled. It's pretty close. I'll let the jury sort it out. And if they can't sort it out, then I'll sort it out after the trial's over.
Thank you, Your Honor. Again, Ms. Montgomery, can you please provide the jury with that estimate?
Yes. As I was saying, the total value of my items was about $1,275, and that's being conservative. I mean, the dish soap in my fish tank, my curtains, everything, my home.
Ms. Montgomery, based on your perceptions, were the two intruders finished vandalizing your home by the time that you got there?
Well, no, given that they ran out of my bedroom while I was there, no.
What happened to your hallway mirror specifically?
Oh, yes. Someone wrote on it in permanent marker. The same darn thing Jules screamed and the same thing I heard on the phone, you will pay.
Let the record reflect that I'm showing what's been previously marked as Exhibit D to opposing counsel.
You may approach.
Thank you, Your Honor. May I approach the witness?
Yes, you may. Is there an objection, counsel, to the photograph of the mirror?
There's no objection, Your Honor.
All right, I'll admit it. You can ask her about it.
Thank you, Your Honor. Ms. Montgomery, was there anything about the quality of the writing on this mirror that stood out to you?
Yes. I noticed it looked similar to a letter that had been misdelivered to my house earlier.
Can you talk a bit about the appearance of that letter?
Yes. Jules's address was in the return address spot on the envelope.
Do you get letters from Mr. Capps often?
Yes. Ever since I moved in, our mail's been getting mixed up. Usually we exchange it, but yes, it happens often.
In your knowledge, is there any other reasonable explanation as to why you would be getting letters from Jules Capps?
No. I knew it was from Jules. Our mail gets mixed up all the time, and her return address was there. And
let the record reflect that I'm showing what's been marked as Exhibit B to opposing counsel. May I approach, Your Honor?
Yes, you may approach the witness and the bench.
Thank you. Ms. Montgomery, do you recognize this document?
Yes, this is the envelope of the letter that had been misdelivered to my house.
Is this a fair and accurate picture of that envelope?
Yes, it is.
Your Honor,
I'm sorry.
Sorry, the state offers Exhibit B into evidence.
Any objection?
No objections.
If it's admitted.
What did you do once you realized you had this letter in your possession?
I got it out. I opened it. The note inside just said, "Thank you, Jules."
Let the record reflect that I'm showing what's been previously marked as Exhibit A to opposing counsel.
You may approach.
Thank you, Your Honor.
Everyone, you may approach me and the witness.
Ms. Montgomery, can you identify this picture?
Yes, this is the note that I found inside that envelope.
Is this a fair and accurate picture of that note?
Yes, it is.
Your Honor, the state offers Exhibit A into evidence. Its authenticity has been stipulated.
Any objection?
No objections.
It's admitted.
Was there anything about this note that stood out to you?
Yes. The handwriting on it looked similar enough to the handwriting on the mirror that I hired an expert to analyze them.
Thank you, Ms. Montgomery. No further questions, Your Honor.
Cross-examine.
Yes, Your Honor. However, before I begin, may I ask that this demonstrative be taken down?
Yes, yes. And move the tripod so Mr. Parikh will be able to move about.
May I proceed, Your Honor?
Yes, sir.
Mrs. Montgomery, I'd like to begin with the damage to your property. I believe I heard you say that $1,275 worth of damage occurred during the break-in.
Yes, and as I said, that's being conservative.
What I'd like to focus on is which intruder damaged your property. Now, when you arrived at your home the night of July 8th, you didn't see any of the intruders damaging anything, that's correct?
I saw them running out of my bedroom.
So you did not see the intruders damaging your property when you returned home?
No.
Let's talk about some specific damage. Now, you testified about a bottle of cologne that was destroyed in your home that night?
Yes, my great-grandpappy Svetson.
Ma'am, you'd agree that that cologne was worth about $300?
Yes.
Ma'am, you don't know which intruder broke that bottle of cologne, do you?
I don't think it matters.
Ma'am,
There were two people who vandalized my house. They were accomplices. They were equally responsible.
Ma'am, which intruder damaged what property is very important this trial, so I'm going to ask you to stick to answering my questions. You don't know which intruder broke your bottle of cologne, that's correct?
No.
So the intruder you shot, Jay Voorhees, he could have broken that bottle of cologne, right?
I don't know. I just know that my cologne was broken.
So it's a possibility that Jay Voorhees, the deceased intruder, broke that bottle of cologne?
As I said before, I don't know.
Ma'am, I'm asking if it's a possibility that the intruder you shot broke the bottle of cologne. That's all I'm asking. Yes or no?
I don't know if he was in the position to break my bottle of cologne because, as you said, I didn't see him do it.
So, ma'am,
Or
it
not
is
do
possible that the intruder you shot was the intruder that broke your bottle of cologne. That's correct?
Sure.
Ma'am, you also testified about a $400 mattress that you had to replace. I got that right?
Yes.
No, ma'am, again, you don't know which intruder ruined your mattress, do you?
No.
That also could have been the intruder you shot, Jay Voorhees. That's right?
As I said, I'm not in a position to know.
Ma'am, I'm asking if it's a possibility that Jay Voorhees, the intruder you shot, ruined your mattress.
I don't know whether it was a
Ma'am,
possibility
you
or
can
not.
answer this with a yes or a no. Jay Voorhees could have ruined your mattress. That's correct?
Yes. Either of them could have.
That's exactly right. Either of them could have ruined your mattress. And now, ma'am, you also testified about cleaning fees that you had to pay. That's right?
Yes, I did.
You'd agree that you had to pay $250 in cleaning fees to remove soap stains from your living room furniture?
Yes.
Ma'am, you don't know which intruder poured soap everywhere in your home, do you?
No, I wasn't there. When I walked in, they were done. There was so much damage. It didn't look to me like one person could have done it on their own, and there were two people in the house.
Well, to be clear, you didn't see soap in either of the intruder's hands when they confronted you. That's correct?
No, I saw a knife and a gun.
Ma'am, just to break down what we talked about, $300 for a bottle of cologne, plus $400 for a mattress, plus $250 in cleaning fees. You'd agree that that's $950 collectively?
I'm sorry, you forgot my flat screen?
I'd agree that you had more damage done to your home that night, but just for the three things that we talked about on this cross-examination, you'd agree that that's $950 of damage?
Yes, but as I said, you're forgetting my TV. I didn't even include my grandpappy's prize duck head that got destroyed.
Well, to be clear, even for that TV, you don't know which intruder broke your TV.
All I know is that it cost me $500.
Well, let's add that up. So that's the $950 that we just talked about, plus $500 for your TV. Ma'am, for all that damage, you have no knowledge to suggest which intruder was responsible, right?
My entire house was ransacked. There was enough damage for 5 people in there to have done it.
And so you'd agree that we have no knowledge as to which intruder was responsible?
Sure, no.
Ma'am, let's move on and talk about the second intruder who you said fled out your back door. That's correct?
Yes.
Now, ma'am, you said you smelled what could have been skunk as that second intruder went out your back door?
It was so strong and nasty.
First of all, when you first came home that night, you didn't notice any skunk smell in that moment, did you?
No, I might have. I had just returned from a jog, so I wrote it off, thought it could be my sweat, but no, it was worse.
Well, ma'am, I'm talking about when you first entered your home that night. You didn't notice any skunk smell, that's correct?
No, as I said.
Well, even when the intruders came out of your bedroom and confronted you, you didn't notice any skunk smell at that moment either, that's correct?
I was a little preoccupied with one pointing a gun at me and threatening my life.
Ma'am, I understand that, but I'm just asking about what you did or did not smell.
I don't remember if I smelled skunk or not.
The truth is, the only time you remember smelling any skunk smell at all was when that second intruder went out your back door. That's correct?
It was a blur, but I definitely smelled it when the intruder ran out the back door.
Let's talk about some identifying characteristics of that second intruder. You'd agree that that intruder's identity was fully concealed?
As I said, gloves and a clown mask. Yes.
That's exactly right. Gloves, a clown mask, and that intruder was also wearing a full body jumpsuit. That's correct?
Yes. It was terrifying. They looked like cartoons.
That intruder was also wielding a knife.
Yes, as I said.
And you told the Jinx County Sheriff's Office about all four of those things. The mask, the knife, the full body jumpsuit, and the gloves. That's correct?
Of course.
But you have no knowledge that the Jinx County Sheriff's Office recovered any of those four items during their investigation. Do you?
Why would I? No, I don't know if they uncovered them or not.
The last thing I'd like to discuss is what could have motivated this break-in. Ma'am, you're a gambler, aren't you?
No?
Well, you enjoy gambling on horse racing, isn't that true?
Objection, Your Honor. This is improper character evidence.
Response.
Sure.
Your Honor, I have two responses. First, gambling itself is not a character trait, and it's not necessarily indicative of any specific character trait, so it's not character evidence. However, even if this court believes that gambling is indicative of some character trait, I'm not using the fact that Mrs. Montgomery gambled to show that she had a propensity to gamble on some other particular occasion. I'm using the fact that she gambled to prove that this break-in was likely motivated by gambling.
And how is that, Mr. Parikh, that even if she did like to play the horses, that somehow is relevant to the issue that somehow this break-in was motivated by some gambling issue?
Well, Your Honor, it's our theory in this case that the intruders who broke into Mrs. Montgomery's house were there to collect on a gambling debt and were enforcers for an illegal gambling operation.
And so the fact that she likes to gamble how does that relate to that?
Well, Your Honor, if we're establishing that Mrs. Montgomery likes to gamble and that she likely owed debt to a bookie, and for that reason, intruders came to her house and were there to collect on that debt.
All right, I'm going to overrule the objection, and I'll give you the opportunity to try to tie it up. If you want to raise that later, then I'll consider it based upon the other evidence in the case.
Thank you.
So overrule.
Thank you.
Proceed, Mr. Parikh.
Yes, Your Honor. Mrs. Montgomery, you enjoy gambling on horse racing?
Yes, I do. Who doesn't love a little sports betting from time to time?
You enjoy gambling on football also, that's correct?
Yes.
You've lost money gambling on both horse racing and football, that's true?
Yes, but I have no gambling debt.
Well, these intruders you told us about, who wrote, "You will pay" on your mirror, you said they were armed?
Yes.
One was armed with a handgun and the other a knife?
Yes, they were both armed.
Mrs. Montgomery, you're aware that the deceased intruder was an enforcer for an illegal gambling operation?
No, no.
Regardless, to the best of your knowledge, the police never collected your financial records to investigate whether you were in gambling debt. That's true?
I have no idea as to the inner workings of the Jeans County Sheriff's Office investigation. I don't know if they collected my phone records or my money, my bank records or not. I'm not in gambling debt.
Well, ma'am, you'd at least agree that the Jinx County Sheriff's Office never asked you to provide those financial records?
No, I'd assume they'd go straight to my bank for that.
Thank you, Ms. Montgomery. No further questions, Your Honor.
Redirect.
A brief redirect, Your Honor. Ms. Montgomery, can you briefly describe the smell of the Svetson cologne that was smashed during the robbery?
Yes, it smelled like my gramps. Sandalwood, florals. And didn't smell like skunk. It was pleasant. It reminded me of my great-grandpappy.
Would you say that to you, that scent is distinct?
Yes.
Thank you, Ms. Montgomery. No further questions, Your Honor.
Recross.
And nothing further, Your Honor.
All right, thanks, Ms. Montgomery. You may step down.
Thank you.
Call your next witness.
Your Honor, the state calls Dr. Brady Stoker.
All right, so this is Dr. Stoker.
Yes, sir.
You're Dr. Stoker? All right. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Proceed. Ms. Cherry Poulet, will you be doing his direct?
Yes, Your Honor, and additionally, may my co-counsel and I set up demonstratives before we begin?
Yes, you may do that. That's the goose and gander rule again.
And, Your Honor, would they use those demonstratives for position or reposition myself to see them better?
Yes, you may. Where are you from, Mr. Dr. Stoker?
Oh, I've lived in Salem my whole life, sir.
Okay, so you're local and you didn't have to fly in for this?
No, unfortunately, well, not unfortunately. I do love my county, although I've gone to other places for my education.
All right.
May I proceed, Your Honor?
Yes, Ms. Cherry Poulet, I'm done.
Thank you. Could you please state your name for the court?
Yes, of course. My name is Dr. Brady Stoker, but all my friends just call me Brad.
Thank you, Dr. Stoker. Now, what do you do for a living?
Well, for the past 14 years or so, I've worked as the lead handwriting analyst and expert for my company, Stoker Forensics. You could say that handwriting and I go hand in hand.
What got you into that line of work?
Well, when I was just a boy, I was left-handed. So every day after school, my teachers would tie my left hand behind my back and force me to write thousands of times on the blackboard, the same message. I miss those days. It's when I fell in love with my handiwork.
Have you prepared a curriculum vitae?
Yes, ma'am, I have. And fun fact, did you know that curriculum vitae means the course of one's life in Latin?
Let the record reflect I'm showing a copy of Exhibit E to opposing counsel. May I approach?
Yes, you may approach me and show the witness.
Thank you, Your Honor. I just handed you Exhibit E. Could you please identify yourself?
Yes, ma'am, this is my curriculum vitae.
Is this a fair and accurate copy of that document?
Yes.
Your Honor, I'd like to enter Exhibit E into evidence. Its authenticity has been stipulated.
Any objection?
No objections, Your Honor.
It will be admitted. You may proceed.
Dr. Stoker, you have your CV in front of you. Could you please elaborate on your achievements and experience in the field of handwriting analysis?
Yes, I'd love to. As you can see here, I've received 2 professional handwriting certificates, and I'm also a member of 3 forensic science societies. I've also written a few publications myself, my favorite being my PhD dissertation titled Decoding the Linguistic Slant, Unraveling the Right Word Bias in the Zodiac Killer Ciphers. I've also attended 3 universities, 2 of which I was summa cum laude in. Fun fact, did you know that summa cum laude means with the highest distinction in Latin?
That's very impressive, Dr. Stoker. And have you ever testified as an expert in court?
Yes, ma'am, 83 times.
Your Honor, I'd like to tender Dr. Brady Stoker as an expert in the field of handwriting analysis pursuant to Rule 702, which qualifies a witness as an expert based on knowledge, skills, experience, education, or training.
I'm not sure about your rules. Do you have voir dire? Do you voir dire the witness on qualifications?
Your Honor, I believe voir dire in this trial is prohibited, but I have no objection to the an expert in handwriting analysis.
Well, then that solves both our problems, doesn't it? Okay, no objection. He's qualified. You may ask him.
Thank you, Your Honor. Dr. Stoker, what brings you to court today?
Yes, well, I was paid for my time as an expert to provide my opinion on this case by an old friend of mine, specifically regarding the analysis between two handwriting samples.
Dr. Stoker, you mentioned an analysis. What was the goal of that analysis?
Well, the goal of that analysis was to determine whether or not these two handwriting samples were written by the same author.
What was the first sample you were given?
The first sample I was given was a letter signed Jules Capps.
What was the second sample?
The second sample I was given was a 300 dpi photograph of a mirror with the threat "You will pay" written on it.
Your Honor, may we flip over to the demonstratives of Exhibit A and Exhibit D, both have been entered into evidence.
Yes, you may.
Thank you, Your Honor. And may my co-counsel publish copies of those exhibits to the jury?
Yes, you may.
Thank you.
And Your Honor, at this time, may I reposition myself?
Yes, you may. All right, so what are we looking at here? We're looking at "You will pay,"
Yes, Your Honor.
and that is exhibit what?
That's Exhibit D and Exhibit A.
Exhibit D and B?
Exhibit A.
D and A.
Yes, Your
Okay,
Honor.
I'm ready.
Thank you. Dr. Stoker, what process did you use when analyzing the two samples?
Well, like any one of my many analyses, I followed my trusty BVC protocol. BVC stands for Baseline Variable Compare.
Your Honor, may the witness step down from the stand to interact with the demonstratives?
Sure.
Thank you, Your Honor. You mentioned that your first step was the baseline step. Could you tell us a bit more about that?
Yes, of course. The baseline step is when I look at a sample that I've never seen before and look at its unique identifying handwriting characteristics to create a profile for that author. Here I use the letter as the baseline sample.
What stood out to you about the letter?
Well, looking at the sample, you can see a distinctive capital Y character that distinctively connects to another distinctive lowercase o character. Tall letters such as T, H, Y, capital J, and capital C have a right tilting slant, and there is a trend of letters being closely spaced together, which is often indicative of haste.
The second step you mentioned was the variable step. Could you please elaborate on that?
Yes, of course. The variable step is when I look at a sample that I also have not seen, that is a different sample, and look at its unique identifying handwriting characteristics to create a profile for that author. And I do not know yet if this is the same author as the other sample, and here I use the mirror as the variable sample.
What was distinctive about the variable sample?
Well, looking at the variable sample, you can see a trend of tall letters having a right tilting slant, and you can also see that many letters are closely spaced together. This sample also includes a distinctive capital Y and lowercase o character, which are both distinctively connected, and the tips of the letters appear blotted, which often corresponds with haste.
Finally, what does the compare step mean?
Yes, of course. The compare step is when I compare the similarities and differences with each sample, and that way I can objectively determine whether or not they were written by the same author if the profiles match.
And what did you notice when comparing these two samples?
Well, let's take a look at some of the defining similarities between these two samples. The same distinctive capital Y and lowercase o characters that are connected in the same manner appear in both samples. The same trend with tall letters having a right tilting slant is consistent with both the letter and the mirror, and the trend of closely spaced letters is also consistent. And both samples share the same word "you" written in nearly identical manners.
Thank you, Dr. Schultz. You may be seated.
The court has a couple of questions for you, Dr. Stoker. Please sit down. So the BVC methodology, have you published on that?
Well, I've used it in many of my analyses because it is the golden standard of the industry. And I've used it in my works that I've published, such as the Decoding the Linguistic Slant, my PhD dissertation, as well as Don't Get Curved, Relational Handwriting Analysis, and All's Fair and Lithography in War, experiential pointers for forensic analysis. So it is standard in my practice, yes.
All right, proceed, counsel.
Thank you, Your Honor. Just one more question. What conclusions did you draw from your analysis?
Well, when I was looking at these two samples, it became clear that the similarities were as uncanny as fresh peaches. And it was
Uncanny as what now?
fresh peaches.
Okay.
Good on the candy.
Okay.
Anyways, it was clear that both of these samples share the same identifying characteristics Therefore, their profiles were consistent and therefore written by the same author.
Thank you, Dr. Whitaker. No further questions.
Cross-examine?
Yes, Your Honor. Before I begin, may I ask that opposing counsel remove the demonstratives? And Your Honor, may I also
Yep, take all your gear down. Mr. Royer, the courtroom is yours.
Yes, Your Honor. And may I also have permission to set up my own demonstrative in the law?
Yes, you may. Will you be using the same exhibits?
Exhibits A and D, Your Honor, are both evidence.
Very well.
Now, Dr. Stoker, I want to begin with something that Ronnie Montgomery told us about. You know absolutely nothing about the damage that occurred in Ronnie Montgomery's home. That's right?
Well, it was clear that that mirror was defaced with a permanent marker, but I can't testify to all the damage, of course not.
That's right. The only damage that you have any personal knowledge about is that mirror. That's right?
Yes, the same mirror with the handwriting that was on that letter.
But you have no personal knowledge as to which intruder damaged which property in his home. That's right?
Well, sir, I did match the person who wrote on that mirror as Jules Capps.
But that's a yes, you don't know which intruder damaged any of the other property?
Not any of the other property, no.
Now, I want to talk about why you're testifying today. You were not hired by the state of Tennessee. You were hired by Ronnie Montgomery, the homeowner.
That is correct, sir.
You and Ronnie Montgomery have been close friends since graduation.
Yes,
right?
sir.
You frequently go on hiking trips with each other every month? That's
Yes,
right?
I'm a big leg guy.
And you also go to music festivals together. That's right?
Of course, not to be unprofessional, but I love the song YMCA. Being able to embody those letters in my own body is quite an experience.
Sir, he's even named you his contingent beneficiary for his...
Objection, Your Honor. Lack of personal knowledge. Pursuant to Rule 602, witnesses must have personal knowledge of something to testify to it. This witness has not made Ronnie Montgomery's will, nor have they seen Ronnie Montgomery make it. So this witness does not have personal knowledge as to the fact that they're the contingent beneficiary of Ronnie Montgomery's will. The only knowledge this witness would have of that is through Ronnie telling him that, which is hearsay, and therefore inadmissible pursuant to Rule 802.
Ms. Cherry Poulet, you and Mr. Royer are both a step ahead of me. I'm still back at the YMCA. So, Mr. Royer, please state your question and make sure I got it. And then Ms. Cherry Poulet, I will hear your objection.
Yes, Your Honor. My question was, Ronnie Montgomery has named you a contingent beneficiary for his retirement options and stock.
All right, so the question is Dr. Stoker a beneficiary of the will of Ms. Montgomery's will? And your objection, Ms. Cherry Poulet?
Yes, I objected to lack of personal knowledge. Pursuant to Rule 602, witnesses must have personal knowledge of something to testify to it. This witness did not make Ronnie Montgomery's will, so the only knowledge this witness would have as to what is in Ronnie Montgomery's will is through hearsay, which is inadmissible.
Ask him if he knows and how he knows.
Yes, Your Honor.
Thank you, Your Honor.
Would you like me to preface, Your Honor, with the fact that he is that, or do you want me to just ask?
Does he know? Does he know if he's a beneficiary? And how does he know that?
Yes, Your Honor. No, sir, you are a contingent beneficiary for his retirement account and stock options. That's right?
Well, Ronnie has mentioned that to me, but I've never seen his will or anything.
That's right. Ronnie Montgomery has told you that you are that. That's right?
Yes, he's mentioned it to me.
Objection, Your Honor. Hearsay. Opposing counsel has just asked this witness to testify as to what Ronnie Montgomery told him. That is hearsay because if they are still trying to establish that this witness is the contingent beneficiary of Ronnie Montgomery's estate, then the fact that they would be the contingent beneficiary would be made for the truth of the matter asserted, and therefore it is hearsay.
Response, Your Honor?
Yes, Your Honor. Yes. Mr.
Yes, Your
Royer.
Honor. As for the hearsay objection, we're not offering this for the truth of the matter that asserts that he is actually a contingent beneficiary for his retirement accounts and stock options. We're rather offering it for the effect that it had on his conclusions in this case and his credibility as an expert witness. And Your Honor, I'm happy to issue a limiting instruction to the jury that they should not take this statement for the truth of the matter that it asserts, but rather focus on how it could have affected his bias in his conclusions.
Your Honor, if I may, the question itself did not ask anything about what Dr. Stover believed from Ronnie, or if he had believed what Ronnie had told him about the contingent beneficiary. It was just, what did Ronnie tell you, which does call for hearsay. I, however, would be okay with the limiting instruction to the jury and a rephrasing the question, Your Honor.
So let me tell you what puzzles me, Mr. Royer. If you're not offering that for the truth of the matter asserted, you say that you're offering it to show some bias. Is that what you're offering it for?
Yes, Your Honor, to show the effect that it had on his conclusions and his bias towards Ronnie Montgomery.
Okay, but it is a fact. You're asking him about a fact that he doesn't know, that's based on what Ms. Montgomery told him. I don't see an exception to the hearsay rule, so I will sustain the objection. I will sustain the objection.
Now, sir, Ronnie Montgomery, actually, I'll move on from that. Next, I want to talk about the samples that you reviewed and said that they were written by the same person. Now, firstly, your standard practice in reviewing a handwriting sample, you require a 20-character minimum, that's right?
Yes, that is the standard for BBC, which is the industry standard too.
Right, but the mirror sample that you reviewed, it only had 11 characters on it, that's right?
Well, yes, sir. The standard is for the baseline to have around 20 characters. It is standard in my practice to compare what has been established as a writing profile for the baseline to less characters for the variable, because I already know what the profile for the baseline's writing looks like.
So, just so I'm making sure I understand this correctly, your baseline sample could have 100 characters, your variable sample could have 5, and you're telling this jury that as long as your baseline sample has a minimum of 20 characters, you can compare those and say that they match?
Well,
Objection, Your Honor, that's a compound question.
That's I'll let him answer that. If you answer both of his questions.
yes, please. Could you please restate that, though? It's
Yes, sir. If you have a baseline sample with 900, 100 characters, a large amount of characters, and then your variable sample with 5 or less, you're telling this jury that you could compare those and find that they are matched simply because the baseline has a minimum of 20 characters?
Well, I want to respond to that in two parts. The first part is that 5 characters for the variable, it is absurd. And I'm lucky enough to have twice that on this sample, which I consider to be normal by my expertise. And also, if I had 900 characters for the baseline sample, well, it would be very easy to compare that with anything, because that is a substantial amount of evidence.
I guess I'll just ask you this, Dr. Stoker. You yourself admit that you wish you had more characters to compare. That's right?
Well, yes, I do wish that the letter itself had 20, but I took that letter from a pool of 87 characters, including the envelope, and those 18 characters were just perfect to analyze. They included everything that I, as an expert, know would be efficient enough to analyze.
Now, Doctor, I want to talk about your conclusion that these 2 handwriting samples were written by the same person. One of the primary reasons you concluded this were the lowercase o's present in the sample. That's right?
Yes, that's correct, and how they interacted with the capital I's. Those are both parts of my analysis as a whole.
Well, let's take a look at those o's. Your Honor, permission to margins if it's A and D are already in evidence.
Yes, you may.
And may I move?
Yep.
Thank you.
Your Honor, your position is launched so that the members of the jury can see it as well. Now, Dr. Stoker, can you see these okay?
Yes, sir, I can.
So just to be clear, there was only 1 O on the mirror sample. That's right?
Yes, as we established earlier, establishing traits in a profile on the baseline makes it far easier to compare it to the variable sample, so yes.
That's a yes to my question. There's 1 O.
Yes.
And there's also another O in the word you in your baseline sample. That's right?
Yes, that is correct.
And it's your testimony for these members of the jury that those O's, they're a match. That's right?
Yes, along with the capital Y as well.
Well, let's take a larger, closer look at those O's. Dr. Stoker, you would agree with me that these O's, they look nothing alike.
Not in my practice, no.
So this O has a large downward stroke on the right-hand side, that's correct?
Well, we would classify that as an interior stroke, going down from the top to the right bottom. What you can see, an interior stroke going that same direction is present in the variable sample as well. I'm glad that you brought this up.
Sir, I appreciate that, but we're on time constraints, so I would appreciate if you just say yes or no to my questions. This does have a downward stroke on the right-hand side, that's right?
Yes, as does the variable.
And this O doesn't.
Well, if you look in the top left, it's part of my job to look closely at these letters. You can see a small stroke on the interior going that same direction.
It's nowhere near as pronounced as this O. You would at least agree with me on that, that's
Yeah,
right?
of course not. It was written on a mirror. The size differences when you're writing things have big implications on how you're writing. It's part of my job to recognize those.
But you don't know for certain if that's why this O does not have a slant like this O, that's right?
Well, I know with a high degree of certainty because I've been doing this for 19 years, yes.
So you cannot say for certainty that in this trial, that is why this O does not have a downward stroke on the right-hand side. That is correct.
In my expert opinion, it is consistent.
It's your testimony that you know for certain that is why this O does not have a downward stroke?
Sir, in any expert testimony, there's always a very tiny degree of uncertainty. But I'm sure that that is the same reason why that stroke is there, due to the evidence, and due to the same fact that the capital Y is a loop going into that O, which is also incredibly distinctive.
So, sir, you said it in your answer. You are uncertain that that is the reason that that O does not have a downward stroke on the right-hand side. That is correct.
I said I was certain, but there is always a small degree of uncertainty, so sure.
That's right. And now, sir, as for the mirror, you said that the letters on the mirror had a right side slant. I heard that correctly?
That is correct.
You would agree with me that this mirror picture was taken at a right side angle, wasn't it?
Yes, of course. That was accounted in my analysis.
And you're telling the jury that when they're looking at this mirror sample in the jury room, at this picture that is slanted to the right, that it's obvious to see that these letters are also slanted to the right?
Sir, yes, that was part of my expert accountabilities was to investigate that. That is what I found.
So, one more question, sir. You're telling this jury that although that is slanted to the right, you are certain that the letters are also slanted to the right. I'm hearing that correctly.
Absolutely.
No further questions, Your Honor.
Redirect.
No redirect, Your Honor.
You may step down, Doctor.
Thank you, Your Honor.
Call your next witness.
Your Honor, the state calls Mr. Andy Wilkes to the stand.
All right, Mr. Wilkes.
Oh, good evening.
Raise your left hand. Raise your left hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Oh, of course.
Have a seat. Counsel, you may proceed.
Thank you, Your Honor. Please state your name for the court.
Oh, sure. I'm Andy Wilkes.
Tell us a little bit about yourself, Mr. Wilkes.
Well, I'm a local. Sorry, at least it feels that way. I guess I came to Salem about 3 years ago from my homeland, Gambo, Newfoundland, next to Canada.
What do you do for a living?
Oh, I'm a huge walker, and it ain't no pansy time walking either. I tell you, this is top-notch race walking. I've been pretty serious about my training for the Olympics, but race walking doesn't exactly pay the big bucks yet.
How do you make a living while race walking?
Oh, my first gig in America was at the neighborhood Halloween shop, Spooky Halloween. But unfortunately, I was asked to leave.
Did you have a disagreement with your boss?
Yeah, I had a little misunderstanding. They asked me to do an 8 hours job, and I did the 8 hours of work that they hired me for. But they had a misunderstanding with the whole thing and said I was dishonest.
Were you dishonest?
Oh no, I wasn't trying to be. The whole thing left me mighty sorry, and every time I pass Mr. Capps' house, I'm sure to raise my pinky.
I'll have to take you now to July 5th. Could you please describe what happened that day for the jury?
Sure. I go on the same race walking route twice every day, seen everything 4 times. And July 5th was no exception. So when I passed Mr. Capps' house, he was yelling at Ronnie. I mean, simply letting Ronnie have it, giving him the what for and the for what. And something about being allergic to tomatoes.
Could you hear anything else that the defendant said to Miss Montgomery?
Yeah, they said, you will pay and you will suffer as I have suffered, and that's that's a promise. Oh, if they knew about my pinky technique, I'm sure she wouldn't have been making threats like that.
At any point, did the defendant mention anything about a veterinary or a grooming bill?
No, not that I've heard. Just that you will pay and you'll suffer as I've suffered, and that's a promise.
Mr. Wilkes, I'd like to take you now to July 8th. Could you please describe what happened that evening when you passed the defendant's house for the first time?
Well, when I passed the house, sometime around 1900, sorry, 7 p.m., Mr. Caps was on his porch petting his smelly dog. I nearly dropped my pinky just to cover my nose from the stench of the mutt, and he was sitting right there.
Did anybody else come out onto the street?
Yeah, Ronnie Montgomery went for a run, and at the same time, Jules got out from their spot on the porch and went inside.
I'd like to draw your attention now to Exhibit C. It should be there with you. Is it?
Oh, yeah.
Mr. Wilkes, you are in court here today. Could you please explain what that is for the jury?
Oh, sure. This right here is the mask that was found on the body of the intruder, Jay Voorhees. But what's more important is it's the same mask that Jules ended up stocking far too much at the Halloween shop, and we had plenty of extras at the time of my leaving.
Thank you, Your Honor. No further questions.
Cross-examine.
Yes, Your Honor. Mr. Wilkes, if I understand your testimony correctly, you don't really know anything about the damages inside Ms. Montgomery's home. That's correct?
Oh, that's correct.
So you certainly have no idea which intruder caused which damage?
Why would I?
Let's turn our attention to those race walk training sessions that you mentioned on direct examination. As you said, you always take the exact same route, right?
Yes, sir. I've been doing it for 3 years now, and I'm pretty serious.
Exactly 1 kilometer into your route, you passed the home of Miss Montgomery, right?
Oh, yes, sir.
On the night of the break-in, you passed Miss Montgomery's home twice, right? Once on the way out, once on the way back.
Yeah, it's a whole loop I have, and I've been sticking to it for quite some time now.
And you said that her home is 1 kilometer away from yours, so that's just over half a mile, right?
Oh, I wouldn't know that. I think miles are inferior to the kilometers.
But you do know it's exactly 1 kilometer.
Oh, that's correct. Like every good race walker who's ever done a 5K or 10K, it's 1 kilometer away.
Sir, we're on time constraints here, so I'm going to ask you to stick to answering my questions with a yes or no.
Sorry.
Now, the break-in occurred exactly 1 kilometer from your home.
Oh, that's correct.
And on the night of the break-in, you passed Miss Montgomery's home for the first time at around 7:15 p.m.?
Oh, it was around, as the locals say, 7 p.m.-ish. And yes.
7:15 p.m.-ish, right?
Yeah, that's the same thing.
Now, sometime in that 1 kilometer interval, from when you left your home until when you passed Miss Montgomery's home, you saw a car speeding past you, yes?
Yeah, it was coming right at me quite before I saw all those police cars around Ronnie's house. And in there was Alex Giles and Jay Voorhees.
Exactly. Jay Voorhees, the man who would later die in the break-in, you saw him in that car with Alex Giles, right?
Hours before the whole thing happened, and they were coming away from my race walk, which is towards Miss Caps's house.
Mr. Wilkes, to be clear, this was not hours before the break-in. This was less than 1 hour before the break-in.
Oh, I disagree with you there.
Sir, you said this occurred at 7:15 p.m.?
I said about 7, yes.
By about 7, did you mean hours before 7?
Oh, no. You see, when I looped back around, I saw, it was 9:30-ish when I saw the police cars around Ronnie's house hours before.
Now, the final thing I'd like to ask you about, Mr. Wilkes, is something that Miss Montgomery brought up on direct examination. She said that the fleeing intruder smelled like skunk.
Oh.
Now, Mr. Wilkes, when you passed Miss Montgomery's house, the smell of skunk was so powerful that you could smell it from all the way from the street in front of Miss Montgomery's house. That's right?
Objection, Your Honor. This is a compound question. Also, counsel was testifying.
Response, Your Honor.
Sure, Mr. Royer, right?
Mr.
No, I'm sorry, Mr. Turner.
Yes, Your Honor.
Sorry, Mr. Turner.
Your Honor, that was not testimony. I was reminding Mr. Wilkes of the general area that my question was going to be in. Second of all, it was not a compound question. My only question was that the skunk smell was so strong that he could smell it all the way from the street.
Okay, overruled. Ask your question again.
That skunk smell was so powerful that you could smell it all the way from the street in front of Miss Montgomery's house. That's right?
Well, Jules was sitting on their porch, and so it was pretty close, but he was super smelly of a skunk stench.
That's a yes. All the way from the street, correct?
Like a couple feet, yes.
Thank you, Mr. Wilkes. No further questions, Your Honor.
Thank you, Mr. Turner. Redirect.
No redirect, Your Honor.
You may step down, Mr. Wilkes.
Thank you.
You're welcome.
With that, the state has no further witnesses and the state rests.
All right. In the real world, the defendants would make a motion at this point in time, but I'm assuming that that's not in the rules of the
Yes, Your Honor.
of Jenks County. We don't do that in Jenks County, do we?
No, Your Honor, that's not a rule in this jurisdiction.
Okay. Well, then, Mr. Turner, you may call your first witness.
Yes, Your Honor. The defense calls Mr. Jamie Lay to the stand.
All right, Mr. Lay, come on up. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Proceed, Mr. Turner.
Good evening, Mr. Lay.
Good evening.
Would you please state your full name and spell your last name for the record?
The name's Jamie Lay, and you spell it L-E-I-G-H.
Please tell the jury a little bit about yourself, Mr. Lay. Where are you from?
Well, I'm from right here. Grew up just down the road on Bug Hall. My daddy was a factory worker over to the glue factory just down that way.
And what do you do for a living?
Well, I've had all sorts of jobs in my not so illustrious career. But back in 2018, I really got my life together. And for the past 5 years, I've been working as a confidential informant for the Jenks County Sheriff's Office.
What is a confidential informant?
I guess that depends mostly on what the police want from you. But in general, it's getting close to the criminal activity and sticking your nose where the police can't.
Is that dangerous?
Sure can be. And if your cover ever gets blown, well, you might just find yourself swimming in cement overshoes.
And how do you prevent that from happening, Mr. Lay?
Well, you can't just rightly walk into a criminal's living room and tell them you work for the police. So I have a stolen goods operation.
So do you know why we're in court here today?
I reckon so. It's on account of that break-in over to Ronnie Montgomery's house. The one where that feller got himself shot.
Do you know anything about that incident?
I do. You see, I spend a good bit of my time over to this old watering hole called Maitland Pool Hall. It's the shady underbelly of Salem, and so it's the perfect place.
Lack of foundation. This witness has not laid any foundation as to why he would have perceived Maitland's Pool Hall as sketchy.
That's the shady underbelly
The shady
objection?
underbelly. Yes.
Response, Your Honor.
Yes, sir, Mr. Turner.
Mr. Lay just testified that he's a confidential informant who likes to stick his nose in places where the cops can't. One of the places that he identified was the Maitland Pool Hall. And, Your Honor, if I may proffer, Mr. Lay is about to describe the Maitland Pool Hall and why he thinks it's the shady underbelly.
You been there, Mr. Lay?
Oh, plenty. Yes, sir.
All right, I'll let him testify.
Thank you. Now, Mr. Lay, please continue.
Like I was saying, it's the shady underbelly of Salem, and it's the perfect place for an informant like me to gather some intel. And it just so happens that the feller who got shot, I'd seen him at the pool hall that very same afternoon. And I knew Ronnie, too.
Well, before we go any further, Mr. Lay, did you speak to any law enforcement officials about what you know?
Yes, sir.
Do you remember the name of the officer that you spoke to?
Stevie Pennywise. I was an informant for Officer Pennywise a few years back. And then last July, he hunted me down to see if I knew anything about a Jay Voorhees character. That's the feller who got himself shot. And I'm glad he did it, especially on account of I let him down a few years ago.
Did you provide information to Officer Pennywise in this case?
Sure did. Told him everything I knew.
Mr. Montgomery, did you tell Officer Pennywise whether you knew the homeowner or the deceased intruder?
Objection, Your Honor. Relevance. Pursuant to Rule 401, evidence is relevant if it makes a fact or consequence more or less likely. Officer Pennywise did not testify here today, nor is the state using his investigation to prove anything about this case. Thus, what this witness told Officer Pennywise is irrelevant because because none of Officer Pennywise's facts would be facts and consequence in this case.
Yes, Roger.
You probably don't need to. I'm going to overrule the objection. I'm going to let you, but you need to tie it up.
Absolutely.
Thank you, Your Honor.
Did you tell this officer that you knew the homeowner and the deceased intruder?
I reckon so. I told him all about the pool hall. You see, Jay Voorhees, the feller who got shot, he was a bouncer there. And Ronnie was a regular there too.
Did you tell Officer Pennywise anything else about this pool hall?
I told him about the back office. You see, Maitland Pool Hall's owned by a Mr. Micah Maitland. And Micah was a bookie, you see.
Objection, Your Honor. Lack of personal knowledge. Pursuant to Rule 602, witnesses may only testify to something if they have personal knowledge of it. This witness has not provided any examples that he has seen of Micah Maitland being a bookie or any specific instances in which he's witnessed conduct like that. Therefore, this witness does not have personal knowledge that Micah Maitland was a bookie, and that conclusion is inadmissible.
How do you know he's a bookie, Mr. Lay?
Well, as a confidential informant, I stick my nose in places of criminal activity. So I've seen him in the back before, which I will testify to.
Well, just because your nose is in there doesn't make him a bookie.
Yes, sir, I've seen him engaging in activities.
All right. I'll let you ask about the activities, and I'll overrule the objection for the time being.
Thank you, Your Honor.
Yes, Your Honor. You said Micah Maitland is a bookie. Did you ever see Mr. Maitland in that back room?
Yes, sir, and he would write stuff in books and handle money.
Did you ever see gambling occur around the pool hall or in that back office?
Yes, sir.
And did you see Micah Maitland hanging around in that back office?
Yes, sir, he owns it. It's his back office.
Now, please, sir, continue. What did you tell Officer Pennywise about this pool?
Well, like I was saying, I told him about the back office. Maitland Pool Hall's owned by Mr. Micah Maitland, and Micah was a bookie, and so he'd run his gambling operation out of that back office.
Did you ever see the homeowner, Miss Montgomery, go into or out of that back office?
Yes, sir. Miss Montgomery was what we call a bona fide regular there.
Objection.
Oh,
Sorry, Your Honor, just an objection.
Hang on a second, Mr. Lay.
I would object to improper character evidence. Pursuant to Rule 404, opposing counsel is not allowed to use specific instances of conduct to prove action in conformity therewith. They are trying to use this specific example of seeing Ronnie Montgomery frequent the back of the pool hall to prove a pattern of action that Ronnie Montgomery is indeed a regular at that pool hall, and therefore that piece of evidence is inadmissible.
I'm not so sure that that's what I heard. I think he was asking not necessarily about a pattern of activity, but about an event. But do you have a response?
Yes.
Or did I just make it for you?
Your Honor's exactly right. Not proving action in conformity therewith, rather that Miss Montgomery was frequenting the back office, and on any of those visits, as Mr. Lay saw, could have easily incurred a gambling debt that might motivate this crime. It has nothing to do with making it more or less likely that she gambled in a future particular instance, which is what action in conformity therewith is referring to.
Okay, and so Ms. Cherry Poulet, I'm going to overrule your objection, but you have free reign on cross-examination to ask what he knows and what he doesn't know about Ms. Montgomery's activities there.
Thank you.
So did you see Mr. Montgomery going into or out of that back office with the gambling occurred?
yes, sir. As I was saying, Ronnie was a bona fide regular, always in the back office.
And what about Jay Voorhees? Did you tell Officer Pennywise anything about Jay Voorhees, the deceased intruder?
Well, I heard rumors, but that was all.
Did you convey those rumors to Officer Pennywise?
I did. I told him everything I knew and everything I'd heard.
Everything you knew and everything you heard. What else did you tell Officer Pennywise?
Well, I told him that what I had heard was that Ronnie owed Mr. Micah a bunch of money.
Objection, Your Honor. This is hearsay. This witness is testifying as that he heard people say that Ronnie owed Micah Maitland a lot of money. They are using that to prove the truth of the matter asserted that Ronnie did indeed owe Micah Maitland money, and therefore it is inadmissible hearsay.
Response, Your Honor.
Yes.
This is in no way being offered to prove the truth of the matter asserted. The statement that Mr. Lay just referenced was that Ronnie Montgomery was tens of thousands of dollars in debt to Micah Maitland. Your Honor, we're not offering this statement to prove that truth, but rather that Mr. Lay conveyed that information to the investigating officer, Officer Stephen Pennywise, and Officer Pennywise ignored that information. Your Honor, there's already evidence on the record that Officer Pennywise did not ask Miss Ronnie Montgomery a single question about her gambling debts or her involvement with the local bookie. So understanding the evidence that Officer Pennywise collected is extremely important for this jury when they're faced with prosecuting and locking up my client on the grounds of a potentially shoddy investigation.
Your Honor,
I know. Go ahead, Ms. Cherry Pillay.
Yes, Your Honor. If I may, Officer Pennywise has not testified here today, nor we are not using his conclusion to prove anything about Mr. Capps here today. Thus, if this testimony is only being used to indict an investigation that the state is not using in its conclusion, it is not relevant. Either it is hearsay, and they are using Mr. Lay's statement that Ronnie owed Michael money to prove that Ronnie did indeed owe Michael money, or they are using it to indict an investigation whose conclusion is not relevant in this case.
Response, Your Honor?
Yes, Mr. Turner.
Just because the state has decided not to call the officer that led their investigation does not make the facts of that investigation less relevant. If the investigation overlooked pieces of evidence, true or not, it's important for the jury to understand them. Furthermore, Your Honor, we'd be happy to issue a limiting instruction that everything Mr. Lay is about to say is not to be taken for its truth value, but rather for its effect on Officer Stephen Pennywise.
All right, so I'm going to let you ask, but I will instruct the jury that it's not to be taken as the truth of the matter asserted. And you also have the opportunity to put Ms. Montgomery back on the stand, if you would like, to say that she did know the gambling debt. So proceed, Mr. Turner.
Yes, Your Honor. Mr. Lay, please continue going through what you told Officer Pennywise.
As I was saying, Ronnie owed Mr. Micah a bunch of money, upwards of $50,000. And Mr. Micah was known to send enforcers out to collect debts from people that owed him. And Jay Voorhees, the fellow who was shot, he was one of them enforcers.
Anything else?
Yes, sir. I told the officer that on the day of the incident, I seen Jay having a conversation with Mr. Micah. And then a few minutes later, I seen Jay leaving the pool hall. Next thing I know, I wake up and I find out that Jay had been shot.
Mr. Lay, you mentioned that you let Officer Pennywise down a few years ago. Could you please explain that?
Yes, sir. You see, a few years ago, I was testifying in a high-stakes case involving a mob boss. And when it come my turn to testify, people started making all kinds of threats against me. Sort of like a recant your testimony or we'll make you take a long walk off a short pier kind of thing. And anyhow, I recanted my testimony and I served prison time for it. And I'm real thankful that Officer Pennywise gave me a second chance to testify today.
Thank you for your honesty about that, Mr. Lay. Your Honor, I have no further questions.
Cross-examine.
Yes, Your Honor.
Got a few for him, do you, Ms. Cherry Pillay?
Yes. May I proceed, Your Honor?
Yes, you may.
This isn't your first time in court today, is it?
No, ma'am.
Yes, you testified in the case against Chuck Campbell, correct?
I have. I've testified a few times before.
Yes, and in that case, you made made a sworn statement of what you saw and heard, correct?
Yes, ma'am. You've got that right.
Just like you did for this case.
I believe so.
And in that case, you walked into a courtroom and sat on a witness stand, correct?
That's correct.
Just like you did today.
That too.
But in that case, you lied under oath.
Yes, I did. My life was threatened, and I think anyone in my shoes would have done the same thing.
Yes, but you were convicted for aggravated perjury for that lie.
Yes, ma'am. I served my time, and I would never do it again.
You served 15 months in prison for that aggravated perjury.
Exactly.
Now, I want to talk about the events happening on July 8th. You saw Micah and Jay talking, like you mentioned, correct?
Yes, they were having a conversation.
Yes, and you were about 10 feet away from that conversation.
I was.
And there was music on at full volume at the pool hall.
Yes, ma'am. I believe it was Mania Shane. I feel like a person.
Yes, Mr. Lee. Now, I want to talk about some things that you mentioned on your direct examination. You mentioned that Maitland's Pool Hall is a gambling organization, correct?
Yes, ma'am. That's what I had taken away from it.
Yes, and the examples you listed were seeing men in suits, seeing men exchange money with Micah Maitland, and you wrote stuff down in a book, correct?
Yes, ma'am. I find that quite odd for a pool hall.
So your testimony today is that you saw men exchange money and Micah Maitland wrote down stuff in a book, correct?
That's correct.
You prepared a sworn statement before coming here today?
I did.
You were told to include any and all relevant details in that sworn statement?
Yes, ma'am.
And you did do that?
I did.
And you were under oath when you made this statement?
I was.
The same oath you're under today, correct?
That's correct.
Your Honor, may I approach this witness?
Yes, you may.
Mr. Lay, this is a copy of your sworn statement. Is this a fair and accurate copy of that document?
It is.
Now, I'm going to hand you a pen, and I'd like you to circle where in that sworn statement you said that you saw men exchange money with Micah Maitland and that he wrote their names down in a book. I can help you out with why it's taking so long. It's because it's not in there. You did not include in your witness statement that example of men exchanging money with Micah Maitland and he wrote their name down in a book, correct?
Yes, ma'am.
Thank you, Mr. Lee. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Now, Mr. Lay, when you wrote your sworn statement, why didn't you include the specific instances of gambling-related conduct that you witnessed?
Well, I'm there every day at the pool hall. I see plenty of things.
Did you write in your sworn statement that the Maitland Pool Hall was a gambling operation?
Yes, sir. It was.
And you wrote that in your sworn statement. Did you write that in your sworn statement?
Yes, sir. I did.
Did you find it relevant to highlight each and every specific instance of that gambling that you witnessed?
No, I mean, I'm not too good at writing. I kept it brief.
Thank you, Mr. Lay. Your Honor, no further questions.
Recross.
No recross, Your Honor.
Okay, Mr. Lay, you may step down. Thank you for coming today. Ladies and gentlemen of the jury, you may credit Mr. Lay's testimony as to what he did or did not tell the officer, but not for the truth of the matter asserted. Call your next witness.
Your Honor, the defense calls Mr. Alex Giles.
Mr. Giles. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Mr. Parikh, you may proceed.
Yes, Your Honor. Good evening, sir.
Hi, how are you?
I'm doing well. Will you please state your full name and spell your last name for the record?
Sure, my name is Alex Giles, and you spell it Giles.
What do you do for a living, Mr. Giles?
Well, I'm the owner, operator of a couple coffee shops around town. I actually own one right across the street. It's called Grounds for Appeal. Turns out, a building full of lawyers are what we like to call in my line of work, a target-rich environment.
Now, Mr. Giles, do you understand why you've been called to the courthouse today?
Yes, sir. I've been called here to talk about what happened last summer. where Jay was shot.
Did you know the deceased intruder, Jay Voorhees?
Oh, yeah, sure, I knew Jay. Jay and I, we known each other since we were practically toddlers. We grew up together in Salem, Mass, that is, just outside of Boston. Like brothers, me and him. Anyway, when his family moved down here, so did mine. Like this, me and him was.
Well, I'm sorry for your loss, Mr. Giles.
I appreciate it, but I have to say, I wasn't surprised when I heard what happened to Jay. See, Jay, he ran with the wrong crowd.
What do you mean by that? The wrong crowd?
Well, Jay worked for Mr. Micah Maitland over at Maitland Pool Hall.
How do you know that he worked there?
I actually own a coffee shop just down the road from Maitland Pool. It's called Maya's Cafe. Jay would stop in during his lunch breaks to get what we like to call the Wicked Brew. It's 2 shots of espresso with just a splash of Irish cream.
Sir, when was the last time you saw or spoke to Jay Voorhees?
That's the thing. Last time I saw Jay was the night he died.
On July 8th of 2023?
That's the one.
Objection, Your Honor. Leading question.
Overruled. You can answer.
That is, yes, that's the night, yes.
Can you tell the jury about that?
Sure. So I had just finished work, and I drove to pick up Jay to go on a ride around town.
Where did the two of you go?
We went down Sanderson Street.
Mr. Giles, Sanderson Street was where the break occurred.
Believe me, I
Your
know.
Honor, that was also a leading question.
Don't lead him.
What was that?
Don't lead him.
Yes, Your Honor.
Thank you, Your Honor.
That's a sustain your objection.
Mr. Giles, were you aware that that was the day that the break-in, that was the street where the break-in occurred?
Yes, I am aware of it now. But believe me, I didn't know anything about the break-in until after it happened.
So did you and the deceased intruder drive down Sanderson Street?
Yeah, sure. Jay told me to drive down Sanderson Street, and I hit my clicker, popped the UE, and it drove right down Sanderson Street all the way to Maitland Pool.
At any point during that car ride, did Jay Voorhees mention my client, Mr. Jules Capps?
Mr. Capps? No, sir. I haven't heard of Mr. Capps up until I was subpoenaed to come to court today. No, the only 2 names Jay mentioned on that car ride were Ronnie Montgomery and Micah Maitland.
Sir, because you were with the deceased intruder on the day of the break-in, on the street where the break-in occurred, I'd like to discuss how or if the Jenks County Sheriff's Office investigated you. Did you interact with the Sheriff's Office related to this break-in?
Yes, I did. I was interviewed by Officer, what was his name? Officer Pennywise. That was it. Yeah, it was pretty brief.
Did you tell Officer Pennywise that you were with the deceased intruder on Sanderson Street just a short time before the break-in occurred?
Sure. Yeah, I told Officer Pennywise everything about that.
Well, did you tell him that you dropped Jay Voorhees off at Maitland's pool hall after driving around together that day?
Yes, of course.
Did Officer Pennywise ask you any questions about what Jay Voorhees had said to you in the car, or about the gambling operation at Maitland's pool hall?
No, sir. Nothing like that.
Thank you, Mr. Giles. No further questions, Your Honor.
Cross-examine.
Yes, Your Honor.
Mr. Warren.
May I proceed?
Yes, you may, sir.
That day, July 8th, was stressful at your job, correct?
Right, yes. It was a long day of work.
There were more customers than usual.
Oh, yeah, sure.
The shift left you extremely tired, isn't that right?
right, I was swamped.
So much so, your tiredness that you don't remember what day of the week it was, July 8th. Do I have that right?
I don't remember it exactly, but I heard now. Yes, it's July 8th.
I'm not asking about the date, I'm asking about if you remember the date of the week. It's true that you do not remember that, correct?
Well, I guess when I gave my affidavit, I said I thought it might be a Monday, but it appears that July 8th was a different day than a Monday, yes.
Thank you. And Mr. Giles, do I have it correct in your direct examination that you said that you told Officer Pennywise about driving down Sanderson Street that day?
I told Officer Pennywise everything about Jay, yes.
Do I also have it correct that you told Officer Pennywise that you dropped Jay off at Mike and Maitland's pool hall?
I told Officer Pennywise about my whole interaction with Jay.
You're aware of the pre-sworn statement you took before this trial?
Yes, I am.
In the statement you were asked to include any and all relevant information. Do I have that right?
Sure, of course.
And you did include any and all relevant information.
Yes, I did.
And you were under oath when you gave the statement, correct?
That is exactly right.
Your Honor, may I approach the witness with a pre-sworn affidavit?
Yes, you may.
Mr. Giles, is this an accurate copy of that affidavit?
Mm-hmm.
I'm gonna give you this pen.
Was that a yes?
Yes, sorry, Your Honor.
I'm gonna give you this pen. Could you please circle clearly where in the affidavit it states that you told Officer Pennywise either that you drove down Sanderson Street or that you dropped Mr. Voorhees off at Mike and Maitland's pool hall?
Of course. It says I was with Jay on the afternoon of his death. That's when I told Officer Pennywise.
Do I have it correct that it does not say within that statement that you told Officer Pennywise that information?
Well, I told Officer Pennywise that I was there with Jay on the afternoon of his death, and I told him what he did. Yes, I told him that I was with Jay. So, I told him that Jay and I were together, yes.
I'm not asking you what you told Officer Pennywise. No, I'm asking you if you included that in your statement. Is it correct that nowhere within your witness statement does it mention you telling this information to Officer Pennywise explicitly?
Right there. I was with Jay on the afternoon of his death.
Yes, however, that does not say that you told Officer Pennywise that information.
Well, if I'm telling him that I was with him, I was driving around with him. Sure.
However, once again, that is a no to my question that you did not tell Officer Pennywise that you were on Sanderson Street or that you dropped him off on Mike and Maitland's pool hall.
I told him that I was with Jay on the afternoon of his death. What we were doing that afternoon was driving around on Sanderson Street, and then I dropped him off at Mike and Maitland's pool hall.
Could you please respond with a clear yes or no? Did you or did you not include the information explicitly that you were driving with Jay Voorhees on Sanderson Street and dropped him off at Mike and Maitland's pool hall and then told this to Officer Pennywise? Please, a yes or a no.
Yes, sir. I told him that I was with Jay on the afternoon of his death.
I'm not asking you whether or not you told him. I'm asking you whether or not you included that in your statement. Please, just a yes or a no.
I thought you were asking me if I told Officer Pennywise. No, like I said, I told Officer Pennywise that I was with Jay on the afternoon of his death. What we were doing while we were together was driving on Sanderson Street.
However, none of that information, none of that testimony about you telling Officer Pennywise this was included in your statement. Do I have that right?
No, it's right here. I was with Jay on the afternoon of his death.
I'm not asking you if the information was within the statement that you purportedly told Officer Pennywise. I am clearly asking you whether or not you included that you told this information to Officer Pennywise.
Sir, I told Officer Pennywise that I was with Jay on the afternoon of his death. I was with Jay in the car driving on Sanderson Street where I dropped him off at Maitland Pool Hall.
However, yes or no, you did not include this telling to Officer Pennywise in your statement.
Yes, I did. I told Officer Pennywise that I was with Jay on the afternoon of his death.
Once again, that is with Jay on the afternoon of his death. Do I have it right that does not say Sanderson Street or Mike and Maitland's pool hall?
Sir, in here, I lay out clearly what I was doing. I was with Jay on the afternoon of his death. I didn't say exactly the words, I was with him on Sanderson Street, but I told Officer Pennywise that I was with Jay on the afternoon of his death. I was with Jay in his car, driving down Sanderson Street, where I dropped him off at Maitland Pool Hall.
Thank you, Your Honor. No further questions at this time.
You all have gotten me confused, Mr. Warren and Mr. Giles. So I think the question was, you say that in your affidavit, don't you, Mr. Giles, that Jay specifically asked to drive down Sanderson Street as we got in the car that afternoon?
Yes, Your Honor.
Right. But then you also say that someone had told Officer Pennywise that you were with Jay on the afternoon of his death.
Right. I remember talking to him about that interaction.
Okay. All right. I just wanted to make that clear. Okay, counsel?
Your Honor, may I redirect briefly?
Yes. You may, Mr. Puri.
Mr. Giles, there seemed to be some confusion on cross-examination as to what you told Officer Pennywise, or as to what you included in your statement. Just so the jury is not confused, can you please read the 5th paragraph of your witness statement out loud?
Sure. I can't remember what they, sorry. I remember talking to an Officer Pennywise, who appeared to me to not be interested in what I had to say, and was only checking boxes because someone had told Officer Pennywise that I was with Jay on the afternoon of his death.
So did you tell Officer Pennywise about your interactions with Jay Voorhees on the day of the break-in?
Of course I did.
Thank you, Mr. Giles. No further questions.
Recross, Mr. Warren?
No, Your Honor.
All right, you may step down, Mr. Giles. Call your next witness.
Yes, Your Honor. The defense calls Mr. Jules Capps.
All right, Mr. Capps. Step right up, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please. Proceed, Mr. Royer.
Yes, Your Honor. Please, tell us your name.
My name is Jules, Jules, Capps, spelled C-A-P-P-S.
What do you do for a living, Mr. Capps?
I run a Halloween costume store. Spooky Halloween is the name. I opened it several years ago after a time from the post office, but then my wife, she passed. Halloween was always her favorite time of year. She loved it so much. We called her Spooky, so that's what I named the store.
Are you waiving your right to remain silent to testify today voluntarily?
Yes, sir. Like I said to Officer Pennywise, I have nothing to hide. And these good people, they need to hear what I have to say. So I'll answer whatever questions y'all have for me.
Well then, Mr. Capps, look these good people in their eyes and answer this question. Did you participate in a break-in of Ronnie Montgomery's home on July 8th of last year during which Jay Voorhees was shot and killed?
No, sir, I did not. It's all just so inconceivable to me that they think I broke into Ronnie's house because my dog was sprayed by a skunk. No, sir, that did not happen. I did not break into Ronnie's house.
Are you and Ronnie Montgomery neighbors?
Yes, on Sanderson Street.
Are the two of you friends?
I'd say we were friendly, sure. I mean, we'd see each other from time to time and say hello like neighbors do. But to be honest, I tried to keep my distance.
Why was that?
Well, Ronnie was known around town to be a gambler. Well, I just didn't want to get caught up in all that.
Mr. Capps, I want to turn our attention to July of last year.
Yes, sir.
We heard testimony about a dispute between you and Ronnie Montgomery involving your dog.
Old Kruger. Yes, sir.
Can you tell the jury what happened?
Well, old Kruger, he just like about every other dog. He just gets so agitated around fireworks. You know what I mean. He just gets to shaking so bad. And well, on last July, the 5th, Ronnie was shooting off some fireworks. And I opened the door to see what was going on, and out goes old Kruger, off into the woods before I knew it.
What did you do next?
Well, sir, I was pretty sure I wasn't going to be able to catch old Kruger on my own. So I went over to Ronnie's place to see if he could help me out. I was just so worried. Old Kruger, he's all I have. And anyways, Ronnie was kind enough to help me out.
Were you able to find Kruger?
Yes, sir. Ronnie and I split up and went looking around the neighborhood for a bit. And then out came old Kruger, running back on his own.
We heard testimony earlier that he had been sprayed by a skunk.
That's right, sir.
How did you react to that?
I was upset.
Why?
Well, you all know what skunk spray smells like, right? And I knew that pretty much the only way to get rid of that smell is with tomato juice. Give old Kruger a bath in tomato juice. But as it turns out, I'm allergic to tomatoes.
Did that make you angry?
Yes, sir. At the time, it did. See, it was going to cost a lot of money to take old Kruger to the groomers and have them to get the smell. Well, I just thought Ronnie ought to be good for it.
Now, we heard testimony that you yelled at Ronnie Montgomery that night. Sir, is that true? Did you yell at Miss Montgomery?
Yes, sir. I'm not proud of it, but yes, I did yell at Ronnie as I was taking old Kruger home.
Tell the jury exactly what you yelled at Miss Montgomery.
I just said, I said he needed to pay for old Kruger's grooming.
What else did you say to Miss Montgomery?
Nothing more, sir.
We heard testimony about you saying something about her having to suffer as you would have to suffer. Did you say anything like that?
No, sir.
Ms. Montgomery testified about a series of anonymous prank calls from July 6th to July 8th. Did you make those prank calls?
No, sir. I didn't make any prank calls. I don't know anything about that.
Well, we saw your phone records earlier in trial, and they showed that you did call Ms. Montgomery 10 times from July 6th to July 8th. Did you make those calls to Ms. Montgomery?
Well, yes, sir, of course. But those weren't prank calls. See, after everything that happened with old Kruger, I just wanted to speak with Ronnie, but she would never answer my phone.
Did you know the deceased intruder, Jay Voorhees?
Yes, I knew Jay. God rest his soul. He was a bit of a troubled kid, but I wanted to try and help him out. So I hired him on as a temp at my store in the fall when things were busy. I figured he might be running with the wrong crowd.
Now, sir, Ms. Montgomery testified that there was writing on her mirror that said, "You will pay." Did you write that message on her mirror?
No, sir, I did not break into Ronnie's house. I didn't write a message, that message, on her mirror. No, sir.
Now, there's only one more thing I want to ask you, Mr. Capsis. After the break-in occurred, did you ever talk to the police or give them a statement?
Yes, sir, I did.
Did you give them that statement voluntarily?
Yes, sir.
Did the police ever search your home?
They did, sir.
And did you require them to get a search warrant before you allowed them to search your home?
Oh, no, sir. There wasn't any need for that. I let them look all they wanted to. Like I said to these good people right here, I have nothing to hide.
Thank you, Mr. Capsis. Your Honor, I have no further questions.
All right, thank you, Mr. Royer. Ms. Ross, is this your witness?
May I proceed with cross-examination?
You may cross.
Before I begin, Your Honor, I ask that I be allowed to set up an enlargement of an exhibit that's already been entered into evidence, Exhibit H.
You may do so.
Thank you, Your Honor.
And, Your Honor, may I reposition myself as needed?
Yes, you may, Mr. Royer.
get into the events of July 5th or the events of July 8th, I want to talk about these phone calls and some testimony you made on direct examination. According to these phone records, you called Miss Montgomery 10 times between the morning of July 5th and the evening of the 8th. That's correct?
Yes, ma'am. After everything that happened with old Kruger, I just wanted to speak with Ronnie. I called, and then I called again, and Ronnie, she never answered my phone.
Right, you called again and again. You called Miss Montgomery 3 times on the day of the 6th.
Yes, ma'am, I called.
You called her 3 other times on the day of the 7th.
Yes, ma'am, but she would never answer my phone.
And then finally you called her 4 times on the day of July 8th, didn't you?
Yes, ma'am.
One of those calls was made specifically at 7:21 p.m. on the evening of the 8th.
That's right, I suppose.
You'd agree with me that regardless of any specific timelines, this is the same evening that the burglary at Miss Montgomery's home took place.
Well, yes, ma'am, I heard about that today.
Now, you said to Mr. Royer on direct examination that you made each of these 10 phone calls to Miss Montgomery because you wanted to get your grooming bill paid.
I just wanted to speak with Ronnie about everything that happened.
Is it your testimony today that you called specifically to speak about the grooming bill?
Ma'am, I just wanted to talk about the incident and everything that happened with the old Kruger.
So it's your testimony today that you wanted to talk about the incident and what happened with Kruger.
I just wanted to speak about the incident, but she wouldn't answer my phone.
Mr. Capps, you gave a sworn affidavit before you appeared in court today.
Yes, ma'am, that's right.
You swore to tell the truth, the whole truth, and nothing but the truth,
Yes, ma'am,
and include any and all relevant information to this case.
that's right.
Permission to approach the witness with their sworn affidavit.
You may.
Mr. Capps, I'm not going to ask you to highlight or circle anything. I just want you to follow along with me silently as I read aloud. Specifically, I want to talk about your description of the morning of the 6th when you first started making those phone calls. You say, "The next morning, I saw that someone had rolled Ronnie's trees. It wasn't me, but I'm not sad to see it happen. That fireworks show would have woken the dead. It was so loud."
Yes, ma'am, she was shooting off illegal fireworks. Illegal.
Mr. Capps, regardless of the illegality of those 5th of July fireworks, you'd agree with me in that nowhere in that portion of the affidavit does it talk about your intent when you first made those phone calls to Ronnie Montgomery.
No, ma'am, it didn't talk about the phone calls at all in that portion.
In fact, the only part in your affidavit where you mention the phone calls is when you say, "I didn't make any prank calls," correct?
That's right. I talked to Officer Pennywise and I told him I didn't make any prank calls. But I called Ronnie. She would never answer my phone.
Mr. Capps, the evening of the 5th, you found out that your dog Kruger had been sprayed by a skunk, correct?
That's right.
As you said on direct examination, you yelled at Miss Montgomery.
I didn't at the time.
That's because you were upset about the incident that had occurred.
At the time, I was.
Right, and then the next morning, you awoke to find that Miss Montgomery's house had been vandalized.
That's when I found out, yes, ma'am.
It had been covered in toilet paper, correct?
That's right.
And you weren't sad to see this happen, were you?
Well, ma'am, she was shooting off illegal fireworks, so that's right.
Regardless of your justification, you'd agree with me that you weren't sad to see her house covered in toilet paper.
No, ma'am, I wasn't sad to see it happen.
Now, after the incident, as you said on direct examination, Officer Pennywise conducted a full search of your home.
That's right. I let Officer Pennywise search wherever he wanted to.
As a part of his investigation, he showed you a picture of this clown mask, that's correct?
Yes, ma'am, that's right.
This is a picture of the clown mask that was found on the body of the intruder, that's right?
Yes, ma'am. Our store sells it in every store in the state.
Right, Mr. Capps. Your store stocks plenty of copies of this very same clown mask, that's right?
Along with every other Halloween costume store in the state, that's right.
But regardless of how many stores stock it, you had 1 or 2 copies of this mask left over after the Halloween season concluded.
I believe that's right.
Right, and then after Officer Pennywise conducted that full search of your home, he told you that he found a box of pointy markers with 1 marker missing from the pack.
Black pointy markers. Yes, ma'am.
Right. And then concluded his investigation. That's correct?
That's right.
Now, I want to talk briefly about a thank you note that you sent to your friend, Rosemary.
Yes, ma'am. My good friend Rosemary.
Would you say that this is a fair and accurate picture of the envelope with the letter in it that was addressed to your friend?
Ma'am, I don't have my glasses with me. Do you mind bringing that a little bit closer?
Of course, sir.
You may approach the witness.
Yes, ma'am.
And Mr. Capps, would you say that this picture right here, may I approach
Yes,
the witness,
you may approach.
is a fair and accurate picture of the letter contained within it?
Yes, ma'am. That's a letter.
So you are verifying today that you are the author of this document?
Yes, ma'am. I wrote a letter to my good friend Rosemary.
You've been in court today, haven't you, Mr. Capps?
I have, yes, ma'am.
So you heard Dr. Stoker use this document in his analysis, correct?
I heard his testimony.
And now, you knew the second perpetrator, Mr. J. Voorhees, before this incident took place, correct?
I knew Jim. I wanted to help him out.
I'm sorry, Mr. Capps. He was a seasonal employee at your store.
That's right, a temp. We hired him on when things were busy around Halloween, of course.
And you hired him for 3 years, that's correct?
That's right.
You had a soft spot for Mr. Voorhees, didn't you?
Man, I felt bad. He was a bit of a troubled kid, and I just wanted to help him out.
So that's a yes to my question. When you employed Mr. Voorhees, you had a soft spot for him.
Well, yes, ma'am. I was worried he might be running with the wrong crowd.
Thank you, Mr. Capps. No further questions, Your Honor.
Redirect.
No redirect.
Mr. Capps, you may step down.
Yes.
And Your Honor, I can remove that enlargement from the well at this time.
And Your Honor, at this time, the defense rests its case.
The defense rests. All right, I don't believe that the rules for Jenks County allow rebuttal witnesses. Am I correct? Or do you have a rebuttal witness? Does the state have a rebuttal witness, Mr. Warren?
You are correct. The Jenks County rules do not allow for rebuttal witnesses.
All right, so we ready to argue the case?
Yes, Your Honor. Before I proceed, may I request up to a minute on my time for rebuttal?
Yes, you may.
And may my
1 minute. What? That's all you want? 1 minute?
Yes, Your Honor. That is what Jenks County permits.
Well, I should know the law of Jenks County a little better. I wasn't licensed there back when I used to do what you're doing. Okay, you got 1 minute for rebuttal.
And then may my co-counsel set up demonstratives for the jury?
You may. And they can help you all you need. Same rules apply.
Your Honor, may I once again reposition myself to see the demonstrators?
Oh, sure. Come on up, Mr. Royer.
May I proceed?
You may, Mr. Warren.
Promises made, promises kept. At the beginning of this trial, my co-counsel promised you that we would prove beyond a reasonable doubt that the defendant is guilty of first-degree murder. And we have kept that promise. In order to do this, we first had to assert that they are guilty of aggravated burglary. Now, there are 2 ways that we can establish this. We can either show that the defendant committed vandalism and that this vandalism totaled over $1,000, or that they intended to commit such felony vandalism. Because as felony happened within a home. The defendant is guilty of aggravated burglary. Because somebody died as a result, he is guilty of first-degree murder. It all began on July 5th, when the defendant became unreasonably angry with Ms. Montgomery. Ms. Montgomery and Mr. Wilkes witnessed the defendant shout, "You will pay. You will suffer as I have to suffer," and that's a promise. This same promise was made again over the phone to Ms. Montgomery on July 6th, and these unwanted phone calls continued through to July 8th. Now, on July 8th, the defendant kept this promise. That day, after receiving yet another unwanted phone call, Ms. Montgomery got up on a run. At the same time, Mr. Wilkes witnessed the defendant get up from his seat. But Mr. Wilkes noticed something else. The defendant smelled like a skunk, the same odor that came from the second intruder that night. When Ms. Montgomery returned home from her run, she saw two clown-masked intruders brandishing weapons. She was forced to kill Jay Voorhees in an act of self-defense. These clown masks, the masks worn by the intruders, are the same exact masks that the defendant stalks in his story. Ms. Montgomery also totaled the extent of the damages, and just considering a few of the items, it exceeded $1,000. But what's more, the vandals were not done at the time of her entering her house, which means that regardless of which vandal committed which vandalism, both clearly intended to do even more damage. But one piece of vandalism stood out. On her mirror was written the same promise made to her by the defendant: "You will pay." Our handwriting expert analyzed this and told you that it was an exact match to a letter signed Jules Capps. But you don't have to trust his word. You saw the letter. You saw the mirror. They were visibly written by the same person, the second intruder, the defendant. Throughout this trial, the defense has tried to attack Ms. Montgomery. They claim this is all about some harmless sports gambling. It was not. You know it was not. The evidence shows it was not. This was, is, and will always be about an angry, vindictive neighbor who went too far in retribution and as a result caused a human being to lose their life. Now, they called witnesses to try to bring you to their side, but I want to talk first about what they did not do. They did not present a single piece of evidence that contradicts the testimony of Dr. Brady Stoker. They did not call a single witness who could change what Dr. Stoker told you, that the defendant is the one who wrote on the mirror. This shows that they were the second burglar that night. Now, first they called Mr. Jamie Lay, a career criminal who has been convicted of aggravated perjury, that is lying in court. He also found himself unable to stay within confined towards his statement this day. Next they called Mr. Giles, who, while being an old friend of Jay Voorhees, offered nothing to this case. And finally, they called Mr. Jules Capps, who, while remaining inconsistent towards his statement, still admitted to stalking a clown mask, to making repeated phone calls, and to writing the letter. When you became jurors, you agreed to carry out justice here today. You agreed to follow the law. You agreed that if we proved to you beyond a reasonable doubt that the defendant was guilty of these crimes, that you would find him guilty. We have kept our promise. We have met our burden of proof on all claims, have shown the defendant's guilt on all counts. We ask that you find Mr. Jules Capps guilty. Thank you.
Thank you, Mr. Warren. Mr. Royer?
Yes, sir. May I ask that opposing counsel?
Yeah. Will the state take your signs down, please?
Yes, Your Honor.
May I proceed, Your Honor?
Yes.
Members of the jury, they under-investigated, and they overcharged. The state of Tennessee has charged Jules Capps with crimes that neither he nor the actual second intruder committed. They tried to convince you that this was a case about promises made, promises kept, that 2 armed intruders broke into Ronnie Montgomery's home, one armed with a knife, the other with a gun, wrote "You will pay" on the mirror, and then proceeded to threaten Mr. Montgomery with his life, all because of a smelly dog. But that theory just doesn't make any sense. You don't invade your neighbor's home with weapons because your dog was sprayed by a skunk. No, the state's plan has backfired. Because when Ronnie Montgomery stepped in and defended his home, things got out of hand. Now, the state of Tennessee has failed to meet their burden. Because as we will prove, they had the burden to prove all of their charges beyond a reasonable doubt. Mr. Capps need not prove a single thing in this trial. Members of the jury, that is the highest burden in our criminal justice system. It requires proof to a moral certainty. Throughout the trial, we've highlighted 3 facts that all point to the reasonable doubt in the state's case. Firstly, both the homeowner and the deceased intruder had ties to an illegal gambling operation. You heard Ms. Montgomery on the witness stand. She's a gambler. She was seen frequently visiting the back of the Maitland Pool Hall, where it's known that there's an illegal gambling operation. The same informant that told the police this, Jamie Lay, also told the police that he saw Ronnie Montgomery, that he knows that Ronnie Montgomery owed tens of thousands of dollars in gambling debt, and that Jay Voorhees was known to collect those debts, and that he told all of this information to the police. Which leads me to my second fact. The police failed to investigate the gambling connection. The state tried to stand up here and say we were hiding evidence when they tried to hide this fact from you, because where are the police? They expect you to convict a man of murder when they haven't even presented a single person who investigated this crime. And when we said that they under-investigated, they could have stood up and said, no, that's not right. We call Officer Stephen Pennywise to the stand. But they didn't. Ask yourselves why. What is the state hiding from you? Members of the jury, they didn't want Officer Pennywise to have to answer our questions because they know we get to cross-examine if they call him to the stand. Officer Pennywise, did you investigate the gambling connection? Did you search Maitland's pool hall or ask Mike and Maitland questions? Did you ask the homeowner if they had any gambling debt? Could the words "you will pay" actually be referring to paying gambling debt? The answer is, of course, it could be. The police didn't investigate. And all of these unanswered questions are reasonable doubt. Which brings me to my third fact. The state has failed to prove that the second intruder damaged over $1,000 or intended to damage over $1,000 worth of property. Now, whoever that second intruder was, the state hasn't proven their actions or their intent. Members of the jury, we asked every one of the state's witnesses if they knew which intruder damaged which property. None of them knew. Ms. Montgomery testified to $1,275 worth of damage. But you heard Mr. Parik's cross-examination. $950 of that, every single one of the state's witnesses told you, it could have been the other intruder and not the second intruder. These facts alone are fatal to the state's case because, as the judge will explain to you in a few moments, aggravated burglary and vandalism over $1,000 required the state to prove that the second intruder alone committed these damages or intended to do these damages. Now, members of the jury, that means that even after the state's rebuttal, even if you believe that Jules Capps was the second intruder that night, the law requires you to find him not guilty. Because they under-investigated, then they overcharged. Thank you.
You got 1 minute, Mr. Warren.
Yes, Your Honor. Before I proceed, may I ask the court to remind the jury of the instruction that all testimony by Jamie Lee, all this in general about Ms. Montgomery's gambling debt was solely towards the investigation under Officer Pennywise and not for its truth whatsoever.
Yes, you may, and but you're just asking me to repeat my earlier instruction, but you are to consider the testimony only for what he told the investigator, what he did or did not tell the investigator, and not for the truth of the matters asserted and what he did or did not tell the investigator. With that, Mr. Warren, rebuttal. The bailiff tells me you might have to talk like the guy that does the Federal Express commercials here. You reserved 1 minute, but you used 4 minutes and 45 seconds. So you have 15 seconds left for rebuttal according to the rules. So,
Yes, sir.
So have at it.
Members of the jury, my opposing counsel stopped me today and asked you why we did not call Officer Pennywise. The answer is simple. We did not need to. Without Officer Pennywise, we connected Mr. Capps to the handwriting, we connected Mr. Capps to the clown mask, and we connected Mr. Capps to the promise you will pay. Thank you.
Thank you, Mr. Warren. That was the best 15-second rebuttal I think I've ever heard. Thank you, counsel. The jury will now deliberate, and we will take a brief recess. They will tally up their scores, and then we will come back in here and have some interaction with all of those that were involved and the families and everybody else, and we'll announce the winner of the finals. Before you go, you all did a fantastic job. You really. And what a pleasure it was for me to be here to preside over the finals. And thank you, young lawyers, for asking me to do it. And so before you go, I will tell you that if you look in the problem, you'll see all the list of the past winners. The 1981 winner was Bearden High School, and I coached that team when I was a young lawyer. So I'm delighted to be back with all of you all today. Is my mic not working? Is it working? It's not working? Have y'all been able to hear me? Okay. All right, well, that's good. Rule number 1, make sure you can be heard, all right? So, all right, so the jury will deliberate. We'll be back probably, 10, 15 minutes?
All rise.
All right, please be seated and come to order. Here's the way we're going to do this. We're going to make you wait a minute to get the results. I'm going to make a few remarks. The jury is going to tell you who they are and make a few remarks, and then we'll announce the winners at the very end. So I'm Dwight Tarwater. I'm a justice on the Tennessee Supreme Court, and I'm delighted to be here with you guys today. I'll tell you, I don't tell you a brief snapshot of my career, but I was a trial lawyer, so in case you didn't pick up from how I interacted with a lot of you all, I've tried hundreds of cases, jury trials, and I was counsel to Governor Haslam from 2014 to 2019. Let me see if I can figure out how to.
I don't think the sound system's off.
Sound system's off. Okay, so I'll talk loud. From 2014 to 2019, I went back to my firm and then Governor Lee appointed me to the Supreme Court, and I was, the most humbling part of that was to be asked to do the job of being a Supreme Court justice. But that, I had to get confirmed by the General Assembly, and I was confirmed unanimously by both houses of the House and Senate, and that was a very humbling thing. And my life has been devoted to the law, and when lawyers are admitted to the bar, when they are sworn in, we all take an oath to be professionals and to respect the law and to serve with honor and integrity. That oath goes actually back to the Roman Empire. And in today's world, civility and honor and integrity mean so much. I cannot tell you how my heart jumped when I saw the way you treated each other in this courtroom. You all did a beautiful job. You were a model of professionalism and preparation and integrity. You should be very proud of, now there's going to be a winner and a loser, but you should be very proud of the job that you have done. And you parents out there, you should be very proud of these kids. They've got a tub full of guts to get up here and do this, and it's hard to do. And sometimes, like Mr. Lee, man, you got the short end of the stick on being the witness, but you did a fantastic job, and you blended your humility so well from the witness stand. Mr. Parikh, I treated you exactly like a lawyer would, like I was treated. When you got a witness on direct examination, lead them if you can until the judge tells you not to do it anymore. So that's how you roll. I won't try to call out all of you. Ms. Cherry Poulet, you handle yourself very well on your feet, and but all of you did a fantastic job, and you all have. If I had to miss the Tennessee basketball game, I'm from Knoxville, and they're up by 9 at the half, by the way. I can't imagine a better place to be than to be with you guys. And I'll hang around, and we can visit, and I'll be happy to answer any questions and give you my take on whatever you want privately. But you all did a great job. And the witnesses, you all, are y'all actors? I mean, what is actors and actresses? I mean, this is, so we had, great lawyers, great witnesses, great characters, just great job. All right, so the jury are the ones that actually filled out the score sheets. The only thing I get to do is announce their results, and I'll do that, but I want to give them a chance to introduce themselves to you. So is that how y'all roll here? So go one by one. Heidi, let's start in the back row with you, and for a brief introduction and whatever comments you want.
My name is Heidi Barkus. I'm Vice President of the Tennessee Bar Association. I try cases for a living, and it was an absolute honor to be here today. It was during mock trial that I figured out that I could do what I do for a living. So I hope that you have the same experience, that you realize you can do it. And all of you, I would hire each and every one of you tomorrow if I could. So come see me when you graduate. Two comments. One, be absolutely sure to show the jury whatever you're talking about. So several times as a juror I got frustrated because I wanted to see something so remember you're here for us. And then the second comment, and take this with with a grain of salt and look at your coaches, not me for this, but I thought everybody on cross spent more time looking at the jury and not at the witness, and it felt really weird to me because in the courtroom, it's an exchange between me and the witness, not between me and the jury, and that felt really weird. And both sides did it equally, like your shoulders were turned toward us and the questions were toward us, and that made me uncomfortable. But that's, again, that's, as a trial lawyer, ask your coaches what's going to happen at the next level. Thank you.
Hi, my name is Alex Rogers. I'm on the YLD Executive Committee, and I'm the Director of Career and Professional Development at Belmont Law School in Nashville. No real comments beyond it was a joy to watch you all. You all were wonderful, and I really hope that some of you were some of my students in a few years at the law school.
Well, good evening again. I know I spoke at the ceremony, so I will be very brief this time. But it really was a joy to watch this round. As I told you earlier, I did mock trial in high school, in college, and law school. I love mock trial. Wish I could sometimes do that instead of real trial. But you all are phenomenal. You keep at it, and can't wait to see you in practice one day.
Hey everyone, my name is Darius Walker Jr. I do management side labor and employment law here in Nashville. I want to echo the comments of everybody else. Very, very, very well done. I enjoyed it. I will say both sides, there were times when you asked a question, didn't necessarily get the answer that you wanted and kind of kept going. I think sometimes the jury can understand and you've made your point, so sometimes you're not getting much out of it at that point. But I was on the mock trial team in law school. I've done real trials since I've been practicing. You guys definitely are better than a lot of what we see in court and very well prepared, so I enjoyed it.
Good evening. My name is Alex McVeigh, and I am a judge down in Hamilton County, Tennessee. And actually, I have this guy to thank up on the bench. About 7 years ago, took a chance and I think appointed one of the youngest judges in the country and definitely the state at the time when he was counsel for the governor. So I certainly appreciate having my current job, have him to thank for that. But I want to say to all of you here today, I mean, fantastic job. Certainly seen some familiar faces, having judged this the last couple years. But again, kudos. I speak loudly. Typically, I'm in general sessions court, so I have about 200 cases every day, so it's loud. You can't hear well. I kind of struggled hearing. I just want, this room, I felt like when we first came in, it was loud. The AC unit was loud. I don't know if the mics are working. So just whoever moves on to nationals, that's one thing to kind of see what the room's going to be like and make sure that your jurors can actually hear them. Because I struggled early on hearing both sides, but it got better, I think, when the AC, stopped blowing. So, but kudos, congratulations. Really, you guys were amazing.
Hey guys, my name is Sean Aiello. I am the incoming Young Lawyers president and a civil litigator down in Franklin. I'm not quite as old as Alex. I could hear you guys just fine. But I thought you guys did great. The only critique I have is it seemed like probably for both sides, time management, maybe with your last witness, it seemed like you both got kind of crunched up at the end, just trying to get what you needed to get out of your last witness. So I felt bad for the third witness for being a little bit shortchanged on time, but everything else was great, guys. Glad to be here and good to watch you.
Hi, everyone. I'm Jennifer Sneed. I am in-house counsel and director of the State's Department for St. Jude in Memphis, and I am also the West Tennessee governor on the YLD board, and I echo everything, all the comments that my fellow attorneys have said. You guys did an amazing job. It was definitely a pleasant experience to watch you guys, and look forward to seeing you hopefully after you all pass the bar.
I'm Jim Berry. I'm the current president of the Tennessee Bar Association, and I am retired from International Paper, where I was chief counsel of the litigation group. And you guys did absolutely spot on. It was amazing. Like some of the other people have said here, it would be great to see this quality inside courtrooms from professionals, and the integrity and the civil attitude It was just fantastic. You all did great.
I'm Ross Smith. I'm an attorney with a firm here in Nashville, and I'm also on the Young Lawyers Division board for the Bar Association. Great job. Kind of ditto to what everybody else said. You did wonderful.
I'm Zach Walden. I'm a criminal court judge in East Tennessee. I've served the past 2 years as the chair of the mock trial competition. I'm still on the committee as the long-range planning chair, but since I'm on the executive board for the Young Lawyers now, I get to score the final round. I often don't get to see the final round, so that was a pleasure for me to get to watch this from start to finish. Also, I presided over the original clown mask killer case, and got to be involved in kind of initially drafting this problem, so it was interesting to see your all's takes on it. I'll give you a highlight from each side. I think that like opening and closing, that's the fun part of this, and that's also the part that through practice and coaching you can get really good at. The part that matches closely to lawyer skills, I think, is the direct and cross, even though that's not the showy part of this. And is it side? Yes. You are naturally very, very good at that. What stood out to me is when Justice Tarwater asked you to build some foundation questions and he told you what questions to ask, you on the fly flip those into leading cross-examination questions, and you have some natural skills. So I hope all of you go to law school. In fact, I think I've appointed all of you to a case on my docket on Monday morning, so you're there. But I really hope that you all consider becoming trial lawyers, because you were absolutely fantastic. Dr. Stoker, did you take time to study to become an actual handwriting expert? Because I was 1,000% sold, and you were really funny, but not to the point that it was distracting or filibustering or cross-examination. So, but great job on both sides.
My name is Billy Leslie. I'm past president of the Wild D board, and I also sit on the TBA Board of Governors. This is my 7th or 8th year judging this competition and seeing students come up and present, and it seems to get better and better every year. So kudos to you all kids, to your coaches and teachers and your family for going through all of this. Again, just fantastic job to everybody.
All right, so with that, we've just got one more thing to do, which is to announce the winner. And this is the group. You notice how I'm deflecting responsibility for this. This is the group that picked the winner. In this case, it was very close, and they did not agree. They certainly did not agree with each other. But of course, lawyers are paid to disagree with each other and to do so in good faith. But in a tight contest, University School of Nashville is the winner.